over. Supplemental list, old matter, item number 1.
In the last order, I was directed to file the copy of the record of right, original copy. The original copy they have sent, but it is indeed they have sent it by register. But the copy which I have received by mail, that is already filed. Original copy was directed to be produced, but that is not reached today.
What is this now? Whether you want, see the order dated 29 September, we have said there appears to be some confusion on whether what the government wants to do is merely change the plot number or also change the extent of land.
Yes. My lord, if your lordship will see the order of the Tahsildar, which was impugned before the Honorable Single Judge, that is available at page 35 of the writ appeal, running page 35. In the case is taken up order, I have already heard the objection through the advocate, peruse the case record. Revenue Supervisor Lakhanpur was asked to conduct verification of the contents of the application and to submit field inquiry report. He has submitted his field inquiry report and so and so. It is found that there is incongruity, dissimilarity as to the facts existing in the field. Insofar as the recording of both the plots in the map is concerned, the ROR fact remaining unchanged vis-a-vis the situation of the plots. There is no bearing of the numbering of the plot number so and so in the revenue cadastral map. The actual position of both the plots is clearly mentioned in the statement table by the order dated so and so. In view of the above facts and so as narrated in my order dated so and so, setting right to the numbering of the plot number so and so in the map as per the records facts in the ROR is necessary for keeping the land register and map up to date and also in public interest. Accordingly, as per Rule 34D, correction of the plot number so and so is made in the village map of so. That map is only corrected.
Not the extent of land.
Yes.
No. The question is whether it's only correcting the plot numbers or also extent. See, the question that was raised 29 September, 21 order, you read. The apprehension is that you're not only changing the plot number, but also extent from 1.090 to 0.040. They're losing land. That's the apprehension.
But if your lordship will see the ordering portion of the Tahsildar's order.
No, that's not clear. When he says redraw the map.
Yes, redraw the map only.
No. Only meaning what? Will they get lesser land, more land for those plot numbers? That's the question.
That is
Who's
not
for the
clear.
appellant?
No, respondent. Respondent. I am for the appellant.
I am for the respondent.
He is the
all
writ
right.
petitioner.
You are for the respondent. Sorry. What is your apprehension?
My sole question is to decide whether the Tahsildar has the power on who is under the section 34 of E of the Act under the survey settlement, and that has been decided by the single bench, referring the two decision of this honorable court passed by the division bench. Already the law has been settled. This Tahsildar has no power. It is our authority that after publication of the ROR, the commissioner settlement has the power to change or any court of law.
Not the single.
Not the Tahsildar. Well, accordingly, the single judge has directed making observation in the last para that the authority may approach under the civil court or under the board of revenue of the commissioner.
But 34E, if your lordship will see that which confers the jurisdiction on the Tahsildar to effect the correction in the record of right, E says that any entry therein has no relationship with the existing fact. Page 43. Page 43 of the writ appeal.
My lord, sole constitution if the map and ROR has prepared by the commissioner, my lord, land reform commissioner, my lord.
Commissioner is the regional authority.
And that another authority. How the subordinate officer will change the nature and character and the area the power of the settlement authorities.
My lord, my respectful submission is so far as preparation of record of right vis-a-vis the map, these are the duties of the Tahsildar. But the commissioner is the revisional authority. If there is any error apparent on the face of the record, he can rectify the errors. But so far as this particular case is concerned, this is page, if your lordship will see the page 43, that is 34E. 34E says that any error, that any entry therein has no relationship with the existing facts. See, this mapping position is not in consonance or has no relationship with the existing. That is why the Tahsildar exercise.
No, but as a result, just see what has happened. Come to para 9 of the impugned order.
Yes, madam.
What land is actually the extent of land is 0.040 decimal. You now record it as 1.090 decimal. And what is 1.090 is recorded as 0.40. You're changing the extent completely.
Yes.
In the garb of saying we are just redrawing the map, you're changing the extent, sir.
According to the mapping position, the
Then you can't simply do it suo moto like this.
No, he was noticed. He was heard.
No.
And
This is
apart from
Tahsildar, does he have the power on?
that jurisdiction. Jurisdiction part 34 is clear. So far as this merit of the case is concerned.
There come to para 6 then.
Yes, in para 6, court has, the Honorable Single Judge has deferred this stand taken by the state.
You can't change the RORs. You'll have to go on the basis of the existing ROR as a Tahsildar. See, in the garb of maintaining the ROR, you can't go about changing the extent.
Because the predicament is that by this process.
Some other official will do it. It's not that you're completely helpless or powerless. The Tahsildar doesn't have the power. That's all this thing. You follow whatever procedure has to happen. And the settled legal position is explained by the division bench in this judgment. So you follow that.
But in that way, if your lordship will think, then this 34E order by the Tahsildar, it cannot be challenged in 226 because it is appellable. That's
over now. You see, the challenge of the present petition by the state, present appeal by the state is to an order dated 31st July 2015, passed by the single judge, allowing writ petition civil 10718 of 2015 filed respondents, and setting aside an order dated 15th April 2015, passed by the Tahsildar Lakhanpur, in Miss Case number 1 of 2015, which incidentally was a suo motu proceeding. Paragraph. During the pendency of the present appeal on 29 September 2021, the following order was by this court. Today, the court has been shown photocopies of the original record as transmitted to the learned additional government advocate, (AGA), Mr. D.K. Manvi, by the Tahsildar Lakhanpur. Paragraph. Having heard learned counsel for the parties, it appears to the court that the question before the legal judge revolved around the powers and jurisdiction of the Tahsildar under section 34, bracket small e, rule 34, bracket small e of the Orissa Survey and Settlement Rules, 1962, bracket rules, which reads as under, full stop, rule 34 reads as under, reproducing the impugned judgment itself. Paragraph. In Ganesh Prasad Das vs. Tahsildar Dhamnagar, 1997, 1 OLR 13, a division bench of this court held that in view of the nature and jurisdiction conferred under Section 16 of the Orissa Survey and Settlement Act 1952, comma, the scope of the power under Rule 34 bracket E is to be confined to matters arising after publication of the ROR. Full stop. Paragraph. The learned single judge noted that by the impugned order, which had been passed pursuant to a notice issued on 2nd February 2015 by the Tahsildar, the extent of two plots, namely plot number 752, khata number 137, and plot number 753 appertaining to khata number 161, the extent of the land itself had been changed. No, extent of land as recorded in the record of rights bracket ROR bracket had changed. Full stop. Further, in terms of the ROR, plot number 753 was a pond, and plot 752 was cultivable land. Full stop. The verification resulted in plot 752 being shown as a pond and 753 as a cultivable land. Paragraph. The learned single judge has, following the aforementioned decision of the division bench, held in the garb of exercising a suo motu power, the Tahsildar had in fact far exceeded the scope of his powers and jurisdiction, and accordingly set aside the order dated 15th April 2015 passed by him. Paragraph. Before, the learned single judge has clarified that as regards cause of action arising prior to the publication of the ROR, an agreed party may still avail remedy available provided under the OS Act or by filing a civil suit. Full stop. In short, it was held that the suo motu powers cannot be exercised by the Tahsildar in the manner undertaken, which resulted in the order of 15th April 2015 passed by him. Paragraph. In view of the decision of the division bench of this court in Harihar Mahapatra versus Commissioner of Land Record and Settlement 1998 to 495, it is plain that correction of an ROR and the map has to be made only on the grounds enumerated in Rule 34 and on the basis of a cause of action that arises after the preparation of the ROR and not prior thereto. Paragraph. The court is unable to find any error having been committed by the single judge in only following the settled position of law explained by this court, by the division bench of this court in two decisions, namely Ganesh Prasad Das Supra and Harihar Mahar Supra. Full stop. No grounds have been made out for interference with the impugned order of the single judge. Full stop. The appeal is dismissed.
And let the Tahsildar may be granted liberty to approach the commissioner for necessary.
Whatever. It will be open to the state to see, follow strictly the letter and spirit of the law in taking any further steps. Right.
Supplementary list item number 2.
Item 2, my lords. In this particular case, Mr. Ajodhya Ranjan Das was appearing, my lords. He has been appointed in the government panel, my lords. The brief was last night given to my lords. I pray that this matter be listed on the opening day of the next year, my lords. We'll take instructions and accordingly appear.
Why should we trouble you, sir? Because we are ready. We have the paper book. When somebody gives us the paper book like this, even we got it last night only.
My lords,
we immediately read it up.
my lords,
You have the privilege of saying, I will not read it.
my lords,
I will go and seek an adjournment. We cannot come to you and seek an adjournment. When we get the paper book, we read it. When you get the paper book, you say, let me take an adjournment.
my lords,
That's the difference.
pray at least. my lords,
Do you have the paper book at least in your hand, or have even that?
This matter, Mr. Kanungo has been engaged, my lords. That's why, my lords.
So no, engagement is without paper book.
my lords, we have just instructions, my lords.
No paper book, but only instruction.
Only instructions.
What we'll do is we'll pass it over. At least for our satisfaction, we bring the paper book at
my
least.
lords, my lords,
And on the way, sir, just glance through it
my lords.
and try and tell us what it is about. Pass over.
Deeply obliged.
Item number 3.
None appears dismissed now.
Item number 4.
Your Lordship, in the item number 4, notice has been issued to the opposite party.
In this case, my lord, I am appearing for the respondent number 1 and 2.
Who's for the appellant?
Yes, ma'am.
Yes, sir.
Sir, you might kindly use the other mic, sir, if you do not mind. Tell us, sir.
On behalf of Gautam Acharya, sir, I was representing, but due to his unwell, the matter kindly.
What is the matter about, sir? Did you use the opportunity of reading what it is about? Mr. Acharya gave you the paper book to go to the Chief Justice's court and ask for adjournment, correct?
Yeah, yes.
Did you take that opportunity to read what it is or what?
I have gone through it, but slightly, as per my remember that the petitioner was challenging the right. He has been appointed as a personal assistant to the Vice Chancellor. Then appointment has been reverted back to as a senior stenographer. Then after few times, he has been reappointed as a personal assistant to the Vice Chancellor.
What was his grievance? Why did he go to the court? No time. No time to read. Too busy. Extremely busy. No time at all. You want to get some more time, you can pass it to us. These are all opportunities. Why don't you read that paper book? See, one assurance we can give you, both of us, if you're ready with the matter, prepared to argue, and we are in the position to agree with you, we might allow the appeal. If we do not agree with you, we will not dismiss the appeal, wait for your senior. Will you get a better opportunity?
This is a better opportunity, but I am not.
No. You just heard what I said just now. Suppose after Passover you come back and you argue it well, and we are with you, we'll allow the appeal. All right?
Yes.
Suppose you are not able to convince us, we will not dismiss the appeal. We'll wait for your senior. We'll adjourn it at that stage. Agreeable?
Yeah. Yes, sir. Please pass over.
Item number 5.
May I please? In this case, the appellant had challenged the order dated 5/9/2018 passed by the Honorable Single Judge with a ground that before going to my grounds, I want to draw the kind attention.
No, but we want you to draw our kind attention to delay first.
My lord, delay.
46 days. All right. Always start with that, sir. Always start with that. All right.
My lord, delay.
So we should not remind you that there is delay. You should be aware that your appeal is delayed. It is not our duty to point out that your appeal is delayed. It is your duty to point out to us, sir, my appeal is delayed. That IA I have filed, and you should first move the IA.
My lord.
This is the sequence. You may not be aware,
yes.
but this is how it is normally done, sir.
No, my lord.
You have one remote counsel, you have one physical counsel, right? Mr. Padi is like the comet, Halley's comet. Only once in a while he will appear. Otherwise, he will be in the sky.
I am on disposal of my lord.
He's too busy to appear in the Chief Justice's court. Yes, please tell us about the day application.
Some type it sometimes happen place.
What is it delayed?
nahi.
46.
You have the right book or you have brought the wrong paper book? We'll pass it over.
My lord.
Pass over.
Item number 6.
Item 6, my lord, no instruction. No instruction, my lord.
Item 6.
You're better, sir, now. You are unwell, I think.
Yes, I was quite unwell.
I know for many years, many days you had a sore throat. But I was wondering why you kept coming.
I will be going to AIMS, my lord, during vacation to find out.
Correct, correct. This is our main instrument, sir.
That's main instrument, my lord. Bread and butter.
Nurture it very carefully.
Bread and butter, my lord. I also not.
Correct, correct. All right.
I
No
am
instructions.
for the opposite part number 5, my lords.
I see. All right.
Be pleased to dictate, but some cases, I found that mine doesn't find place.
I see. Yes. All right.
Item number 7.
May I please your lordship? Yesterday, item number 6, OTPL number 6 of 2018. This is a similar matter, my lord. That is goods used for the structural items whether send back credit is admissible or not. If your lordship will remember that Singhal Enterprises, your lordship are directed to take instruction whether it has been pending before.
Correct, correct. This is connected with that.
This is connected.
When is that coming up?
It is on 10th April 2002.
All right. You say list on 10th April along with
OTAPL number 6 of 2018.
All right. OT 6 also. All right.
As well as item number 37 below.
37 also. All right.
In the item number 37, there are some defects. In the meantime, I will remove.
All right. Defects be cured in the meanwhile in item 37.
Much obliged.
All right.
Item number 8.
Item number 8 and 9, my lords, seek an adjournment after vacation. The conducting advocate, Mr. Parida, he is out of station, is attending a conference at Jaipur. And
we don't adjourn for these kind of grounds, sir.
I am telling the truth. Actually, he is the conducting advocate.
I'm very happy that you're telling the truth, sir. But I think it's not a courtesy extended to this court. When the matter is listed in the High Court, you go for a conference somewhere else.
No, it came suddenly, my lords. Abruptly, it has.
No, it doesn't come suddenly, sir. These are not matters coming
It was
suddenly.
not in the reserved list that he could have known, lords.
Why should it be in the reserved list, sir? This is a fresh matter or after notice? One of these. 1 minute. Let's see what this is. There's only an after notice.
No, it's not after notice. Fresh admission.
That's even worse than fresh admission will go in reserve list. I've never heard of this. Will fresh admissions be in reserve list, sir? I don't think in any High Court fresh matters are put in a reserve list.
Fact is, he has gone to attend conference of All India Federation of Tax Practitioners, Jaipur. Not present. The brief is also not with me because he is the conducting advocate.
Sir, tell him this is a hybrid court. From Jaipur also excellent connections are there.
Yeah,
he's so willing, we can pass it over. He can appear virtually also.
Yes, brother.
Please tell him. We'll pass it over. Ask him to appear virtually.
Lordship may bring it tomorrow, then I'll instruct him so that he can appear tomorrow.
Just tell him, sir. Tell him the High Court Chief Justice and one more judge are waiting for his benign and gracious presence in hybrid mode. All right.
All right. All
right. All right.
Pass. Item 8 and 9 pass. Item number 10.
Item 10, all the 3 matters infructuous.
Infructuous dismissed. All right.
Item number 11. Item number 11.
None of is dismissed.
Supplementary list item number 12.
May I please, my lords. Here the assessment order under section 9C of the OET Act, audit assessment order, was passed by the assessing authority. Contrary to the statutory provision 9C6, there are bar by limitation. And to that, I pass on the order sheet, assessment order, record order sheet.
No, is it an appeal?
My lord, it is completely barred by limitation.
No, no. Your order is an appealable order or not appealable
No,
order?
appealable order.
So what do you want to do, sir?
Withdraw the file.
Very good, very good. Counsel, the petitioner seeks leave to withdraw this present petition with liberty to file an appeal as provided under law against the impugned assessment order if such appeal is filed not later than 6th February 2023, accompanied by an application for confidential delay, explaining the delay on account of the pendency of the present petition, to be considered in accordance with law by the appellate authority. If the appeal is filed within the time aforesaid, along with an application for interim relief, until such time that the appellate authority passes an order thereon, the interim order dated 20th March 2008, passed by this court, will continue. The originals will be returned subject to being substituted by attested photocopies. Court clarifies it has not expressed any of the matter.
Item note 13.
May I please, my lords? This writ application, my lords, I've challenged, my lord, the appellate order of the commissioner, my lord, on the ground, my lord, that the so motor authority who has exercised so motor revision, my lord, does not have the delegation of power, my lord, to exercise the powers of so motor laws. Added to it, my lords, I've also challenged the adoption of Rule 12, which is, my lords, applicability of partial input tax credit, so far as the petitioner is concerned. And the third objection, my lord, is towards levy of penalty under 42.5, my lords. Here in a proceeding under 79.1, my humble contention that the penalty is not at all applicable, my lords. So far as the first contention, my lord, of this petitioner is concerned relating to the delegation of powers of the additional commissioner, if your lordship would kindly turn to page 7.
In STO's order, you've directly challenged a writ petition here.
No, my lords. STO order was so moto revised by the additional commissioner.
Where is it? Let's see the 22064, the first writ petition.
Lord, Chief Justice's quote of the first petition was against the order of the commissioner in appeal, where I had said that you please decide the question of jurisdiction as a preliminary issue, my lords. If your lordship would kindly permit me, I've extracted the order of the honorable court, my lord, at page 10, my lord, if your lordship would see, paragraph 12. Lordship got it?
Yes.
Heard the learned counsel for the parties. By way of this writ petition, the petitioner has challenged the order passed by the Commissioner of Sales Tax of Odisha dated 6/12/2018 in revision case number so and so under Annex 1, whereby the preliminary issue raised by the petitioner has been turned down. In our considered opinion, the point has been raised by the petitioner prima facie appears to have force of law, but the same can be challenged along with other grounds after the commissioner decides the appeal if he feels aggrieved. We are not inclined to interfere with the impugned order at this stage. It is made clear that we have not expressed any opinion on the merits of the case. However, it is open to the petitioner to challenge the jurisdiction of the Joint Commissioner of Sales Tax, Additional Commissioner of Sales Tax, even at the time of challenging the order of the commissioner if occasion arises. Then the original documents are. So what had happened, my lord, against the so motor power, my lord, there's a revision, there's an appeal to the commissioner, my lords. Before the commissioner, my lords, I filed an application to decide the question of jurisdiction of the so motor revisional authority, my lords, as a preliminary issue. He refused it. Against that order, my lord, had come up in the first writ petition before this honorable court. This honorable court that while the commissioner was deciding the appeal, you'll also answer the question of delegation of powers so far as the so motor authority is concerned. So we are not interfering at this stage. However, it will be open to for the petitioner to challenge it in the final order of the commissioner and appeals. That is how, my lord, I come up in the present writ application.
No, the commissioner appeals. From there, you go to the tribunal. Right?
No, my lords.
No.
Because
it's revision.
No, my lords. Against the revisional order, my lords, I file an appeal under 79(7) of the Act, my lords. Against that, my lord, there's no further appeal, my lord.
All right. So what is challenged here is your 79(7) order.
My lords.
Where's that?
No, that's Annex 1, my lords. Annex 1, my lord, at page, page 49, my lords. The 79(7) order, my lords. This appeal petition filed by so Tangi, Katak under section 79(7) of the OVAT Act against the so motu revision order dated 12/7/2018 passed by the revisional authority, that is additional commissioner.
1 minute. I'm not getting it.
Page 49, annexure 1.
How many pages are that? Just showed us paper.
The first writ petition, well, I think your lordship are holding the
22064, right?
No, that is 11311. The second, the first
Second writ petition. All right.
That's the second writ petition. So
what is the other writ petition about?
The other writ petition, Lord, pursuant to the orders of the learned commissioner, my lord, the sales tax officer recomputes, my lord, again and imposes penalty.
Yes.
So that is the second writ petition, Lord. That is
it's a consequential one.
Consequential one. That is WPC 22064 of 2019. Lord.
All right.
So I'd be placing the second writ petition where
first
the orders of the commissioner in appeal has been challenged.
Right.
So I have no other alternative remedy rather than coming to your lordship's court, my lord.
Right. So two grounds on which you challenge the notification itself.
In fact, my lord, essentially there are three grounds. And additional lords, subject to your lordship's kind consideration, this order is passed by the commissioner, my lord, on the verge of his transfer. A petition was filed, my lord, because he gets the transfer order on the 2nd of March 2019. He is well aware of his transfer order. Still, my lords, in spite of the fact that the petitioner's counsel was not well, he insists, my lord, that he is to hear the matter and finish it.
All right.
It's on the 8th of March 2019. He passes that order.
All right. Now let's see the other grounds.
So the other ground, my lord, I'll begin with the delegation of powers, my lords.
All right.
Lord, for your lordship's kind consideration, lords, I've your lordship may take up the second volume, lords.
All right.
So that this particular the earlier volume, my lords, this may not be there. That delegation may not be there, my lord, in this particular book.
Older.
The earlier book, my lord, sir. May I just share my book? I've extracted, my lord, the relevant portion in my brief, my lords.
All right.
That is at page 17, my lords.
Okay.
So this is a notification, my lords, of 2008. Lordship got it, my lords?
Yes.
So may I just place this notification?
Please.
In exercise of powers conferred by Section 5 of the Odisha Value Added Tax 2004, Sri So-and-so, Commissioner of Sales Tax Odisha, to hereby delegate the powers and duties to be exercised by the officers appointed under subsection 2 of section 3, read with section 106 of the Act, to the extent as specified in column 2, column 3, and column 4 of the schedule below, within their respective areas of jurisdiction. This has been approved by the government in Finance Department by number so-and-so dated 24th of April 2006 as required under subsection 2, sub-rule 2 of Rule 5 of the Odisha Value Added Tax. I'll be failing in my duties, my lord, if I don't show, my lords, section 5, my lords, and Rule 5, my lords. If your lordship would take up the OVAT Act, lords. The lordship would see. May first take up section 5, my lords.
Yes.
Delegation of commissioners' power and functions, my lords.
Yes.
Lordship got it?
Yes.
Subject to such restrictions and conditions as may be prescribed, the commissioner may, by order in writing, delegate any of his powers and functions under this Act or the rules to any person appointed under subsection 2 of section 3, and any order passed by such authority in exercise of the powers so delegated shall be deemed to be an order passed by that person. Then the lordship may kindly turn to Rule 5, my lords. Sorry, my lords. Just keep on.
Delegation of Commissioner's power.
Your Lordship may take up sub-rule. I'll not bother Your Lordship with sub-rule 1. Your Lordship may take it up at sub-rule 2, my lords.
Yes.
The Commissioner shall not, Your Lordship may kindly mark, to any officer under subsection 2 of section 3 to assist him the powers and under subsection 1 of section 79 without the power approval of the government, my lords. So it's a power of suo motu revision, which is the Commissioner is the original repertoire of all that power, my lords. So if at all he wishes to delegate this power to any of the authorities, this can be done, but with the prior approval of the government, my lords. That is why Your Lordship would find, my lord, in the first notification, they say that this has been approved by the government in Finance Department by letter number so-and-so dated 24th of April 2006, my lords. And Your Lordship may see what is the delegation, my lords. The delegation is subsection 1 of section 79. It is Assistant Commissioner of Sales Tax if the is passed by the sales tax officer, full powers, my lords. Lordship got it, my lords?
Yes.
Subsequently, my lord, this particular assistant commissioners was changed, my lord, and they were redesignated as joint commissioners, my lord. Still, my lord, in that situation also, my lord, if the Lordship would turn over the page,
Yeah.
there was another SRO 79 of 2009, my lords, where in, may I just please page 18?
Yes.
In exercise of powers conferred by subsection 5 of the Orissa Value Added Tax, Orissa Act number so-and-so, in supersession of the earlier notification number so-and-so, dated 17th of July 2008, which I've just placed before Your Lordship.
Yes.
The notification dated 17th of July 2008, I, Sri so-and-so, Commissioner of Sales Tax, Orissa, do hereby delegate the powers and duties to be exercised by the officers appointed under subsection 2 of section 3 to the extent as specified in column 2, column 3 and column 4 of the schedule attached herewith within their respective areas of jurisdiction. This has been approved by the government of in Finance Department by letter number so-and-so dated 30th of April 2009 as required under sub-rule 2 of rule 5 of the Orissa Value Added Tax 2005. There Your Lordship would see, my lord, in the place of a commissioner, it was joint commissioners, my lord. So even in the change of the name from assistant to joint, my lord, approval of the commissioner government was required, my lord, for delegation of powers by the commissioner under 79(1), my lords. In the present case, what has happened, my lord, if Your Lordship would kindly turn to annexation 9 at page 135, my lords. The particular note 135, my lords. Lordship.
Yes.
This is a notification dated 5th of June 2018, my lords. There the commissioner, what he does, my lord, in partial,
yes,
in partial modification of this notification number so-and-so dated 15/5/2019. That is the one which I was just placing before Your Lordships, my lords. I, Sri so-and-so, Commissioner of Sales Tax, do hereby delegate the power and function of the Commissioner under Orissa Value Added Tax and the Orissa Value Added Tax Rules 2005 to the officers appointed under subsection 2 of section 3 of the Orissa Value Added Tax number so-and-so as specified below.
So you say this is without the prior approval.
Without the power approval, my lords. And here what has happened, Your Lordship, see additional...
No, but read para 4.
Para 4, my lords, is this is issued with prior approval of the government by letter number so-and-so dated 34/2009. They are referring to the earlier notification where the joint commissioners, when the powers went to joint commissioner, man, this is still worse because for the first time, additional commissioners are being posted in the range as range heads, my lords. So there was a complete restructuring of the entire cadre structure of the finance, of the sales tax department, my lords. So this, my lord, in my humble submission, it is incumbent on the commissioner, my lord, before effecting such a change and delegating his powers under 79(1), the prior approval of the government is very much necessary, my lords. The second part, my lord, Your Lordship would see, my lord, this particular notification still date, my lords, if my information is correct, has not seen the light of the day. It has not been gazetted. Instead of earlier, Your Lordship would see that each of these bears a SRO number, my lords. And this, Your Lordship would see, a copy in duplicate has been forwarded to the director. That's the first note. Printing so-and-so, this may be published. I filed an RTI application, whether this has been done or not. Your Lordship may turn over the page, my lords. They say at page 138, my lords, in inviting
Yes.
In inviting a subject cited above, I am directed to inform you that the copy of the notification number so and so dated 5/6/2018 has been duly communicated to the Director, Printing, Stationery and Publication, Madhupatna, Cuttack, vide memo number so and so dated 5/6/2018 for publication in the Extraordinary Gazette. However, a copy of the Gazette has not yet been transferred to the Director, Printing, Stationery and Publication. It also needs to be mentioned that prior approval of the Government of Finance has already been obtained by letter number so and so dated 30/4/2009. So 30/4/2009 was a delegation to the Joint Commissioners, my lord. This was not a delegation in favor of additional commissioners heading the range, my lords. So they refer to that particular government of notification, and they want to say that this is the notification which has already got the prior approval of the government, my lords. So my humble contention, my lord, is there has been no delegation of powers of additional commissioner or of the commissioner under 79(1) in favor of additional commissioners heading the ranges, my lords. So this exercise of power, my lords, by the additional commissioner, my lords, in revising so moto, a power of the sales tax officer, my lord, is non-est in the eye of law, my lords. Number one. Number two, my lord, if your lordship, even if conceding for the sake of argument, my lords, that what are the orders, if at all, my lordship would accept for the sake of argument that the additional commissioner has the power, my lord, your lordship may kindly come back to 135, page 135, my lords. Column number 4, my lords.
Yes.
So the lordship got
yes.
A, additional commissioner of sales tax heading a territorial range if the order is passed by a joint commissioner or deputy commissioner of sales tax. Here, my lord, the original order is by the sales tax officer, my lord. That is Annexure 3 Annexure 4 at page 83, my lords.
So it can't be revised by
it can't be revised, my lords. And there the commissioner says, my lord, that we have already got the prior approval. He refers to that 2009. Then he says, my lord, that by the time, my lord, he passes that order, my notification was not there. But I say that is wrong because the additional commissioner has been posted in that place much prior to that particular exercise of power, my lord. And I have given the posting order of that particular gentleman, my lord. If your lordship would kindly turn to Annexure 10, my lords. At page 139, my lords. This is a Finance Department notification dated 28th of May 2018, my lords. And serial number 1, my lords, the person who is responsible, the JCCT Cuttack 2 range, has been posted as additional commissioner CCT Cuttack 2 range, Cuttack, my lords. So, my lord, at the relevant point of time, my lord, also, he was an additional commissioner without the authority of law, my lords. And the commissioner brushes that aside, saying that, my lord, no, by the time he passed that order, this particular notification was not there. It was 2 days prior to the date of the notification that he has completed the hearing, and thereafter he has passed that order. And at that relevant point of time, my notification was not there. So he passed that order as the additional, as the joint commissioner, not as the additional commissioner, which factually is incorrect, my lords.
All right.
And if I succeed, not bother your lordship to the other technical issues of.
Let's see how
it has not been admitted, my lord.
No, what's your answer to this?
That has been answered. Annexure 1, my lord. Page 51, my lord.
Yes.
Delegation of the commissioner's powers and functions, subject to such restrictions and conditions. As
he has already read the section 5, he just now read.
My lord, he has elaborately discussed all this.
Whatever, sir. Where is the prior approval of the government? For this delegation notification, where is the approval of the government? We're talking of the 2nd May 2018.
My lord.
Under which power is given to the additional commissioner.
So instructions has to be taken, my lord.
No. Where's the question of instructions? It's already all discussed, sir. The impugned order discusses it. How do you defend the impugned order? That's the only question here.
Or date may be given, my lord. So date may be given, I will take.
There's no question of instructions, sir, here. It's a pure legal point.
If any counter, my lord, yes, I have understood, my lord.
Sorry?
What I have understood what my learned senior has a short form. his prayer, my lord. Only I have to verify whether that notification, whether that has been gazetted or not.
Not gazetted, sir. There are two arguments here. One is because of the wording of Section 5.
Yes, ma'am.
There has to be a prior approval of the government.
Yes, ma'am.
So that's point number one.
Yes.
Did this have the prior approval of the government? This is Section 5 read with Rule 5.
Yes, ma'am.
I think the prior approval condition is in Rule 5.
Rule 5(2) belongs, sub-rule 2.
What is referred to in that impugn notification is a prior approval of 2009.
My lord.
That is for a different delegation.
Yes.
Now it's been changed. The basis of that notification is being changed, for which there is no prior approval of the government.
Yes.
So that's very obvious. Yes, correct. Has to go, no? Yeah, can't do it. Yeah. Count, yeah, absolutely. Challenge of this repetition is to an order dated 17 September 2019. No, sorry.
8th of
Yeah.
8th of March 2019.
8 March 2019, passed by the Commissioner. Of Sales Tax Orissa. Bracket CST. Whereby the appeal filed by the present petitioner, SSC, under Section 79, bracket 7 of the Orissa Value Added Tax Act 2004, bracket OVAT Act, against the suo motu revision order dated 12 July 2018, passed by the Additional Commissioner of Sales Tax, bracket additional CST, bracket territorial range Cuttack to Cuttack. Under Section 79, bracket 1 of the OVAT Act, raising a demand of rupees 77,99,848 for the tax period 1st April 2014 to 30th September 2015, was dismissed. Paragraph. This court has heard submissions of, just put down, Mr. Karal, learned counsel for the petitioner, and Mr. also learned counsel for the department. Paragraph. The facts in brief are that the petitioner is a dealer registered under the OVAT Act. He carries on business within the territorial jurisdiction of Cuttack. Full stop. The petitioner deals in sale of size wood, logs, and waste of wood cuttings. Paragraph. Pursuant to a tax audit conducted in Section 41 of the OVAT Act, the assessing authority passed an assessment order under Section 42 of the OVAT Act on 3rd May 2017. Allowing certain deductions while computing the tax liability. Paragraph. On 2nd May 2018, the Joint Commissioner of Sales Tax, Cuttack 2 Range Cuttack, bracket JCST, exercising suo motu revision power under section 79(1) of the OAT Act issued a notice seeking to revise the aforementioned order of the assessing authority (AA) on 12 July 2018. The Additional Commission of Sales Tax (additional CST) Cuttack to Range Cuttack passed an order to section 7(1) of the OAT Act relating to the aforementioned tax periods. Paragraph. Agreed by the above order of the additional CST, the petitioner SSC filed an appeal before the CST under section 79(7) of the OAT Act. Full stop. Along with the appeal, the petitioner filed two applications, one for stay and the other raising a preliminary issue as to the jurisdiction of the additional CST to pass an order in suo motu revision. Paragraph. By an order dated 6th December 2018, the CST rejected the application for deciding the preliminary issue. Stop. Agreed by this order, the petitioner filed writ petition civil 179 of 2019 in this court. On 22nd January 2019, the following order was passed. Bottom of page 10, the whole of page 11 and 12. 12 top paragraph. Pursuant to the above order, the petitioner on 2nd March 2019 filed a petition before the CST. Seeking deferment of the proceedings. Full stop. It is stated that on 8 March 2019, another petition was filed on the ground of ill health. Full stop. When this was also not agreed to by the CST, an additional note of written submissions, a written note of submissions was filed. Paragraph. On the issue of jurisdiction, two contentions were raised by the petitioner. Stop. One was that in terms of rule section 5 of the OAT Act, read with rule 5(2) of the OAT rules, for delegation of the powers of CST to the additional CST, which was done by the virtue of the notification dated
135 minutes. Page 135 minutes.
5th June 2018, the mandatory prior approval of the government was not obtained. And therefore, such delegation of power was bad and law. Full stop. The second ground was that the said notification itself had not been gazetted. Full stop. There was also a third ground that even assuming that the delegation was valid, since the original assessment order under section 42 of the OAT Act was passed by the sales tax officer, bracket STO bracket, as an AA, the revisional power could not have exercised by the additional commissioner, additional CST against such an order. Paragraph. As regards the first contention, the CST, while rejecting the plea of the present petitioner, referred to an earlier approval of the government granted on
30th of April 2009.
30th April 2009. Full stop. It was further observed that at the time when the suo motu revisional order was passed, the notification of delegation had not yet been published, and therefore the additional CST who passed the suo motu revision power was still acting only as the JCST. Full stop. Paragraph. Paragraph. This court would like to first consider the correctness of the above conclusion of the CST vis-a-vis the issue of prior approval of the government. Full stop. Section 5 of the OVAT Act reads as under, reproduce that. Paragraph. The above provision is to be read with Rule 5, bracket 2 of the OVAT rules, which reads as under. Paragraph. In terms of Rule 5, bracket 2 of the OVAT rules, the CST cannot delegate to an officer appointed under Section 3, bracket 2 of the OVAT Act, which includes the additional CST and the JCST. The powers of the CST under Section 79, bracket 1 of the OVAT Act, open quotation, without the prior approval of the government, full stop, unquote. The mandatory nature of this requirement of prior approval is evident from the fact that all the early delegation notifications, including the notification dated 15th May 2009, specifically mention the prior approval obtained from the government. Full stop. However, when one produces the notification dated 5th June 2018, in terms of which the CST delegated its power under Section 79, bracket 1 of the OVAT Act to the additional CST, what was referred to was only the earlier approval obtained on 30th April 2009. Stop. That approval was not for delegation of the powers of the CST to the additional CST, but delegation of the powers of the CST to the JCST.
JCST. May I just pass my book? Notifications are them.
You've also set it out here, right?
Malus.
Yes. We'll start. Consequently, that earlier approval of 30th April 2009 was not sufficient to justify the further delegation of powers by the CST to the additional CST, which happened more than 9 years later. Nearly 9 years later, more than 9 years later on 5th June 2018. Full stop. Clearly, therefore, the notification dated 5th June 2018, was contrary to Rule 5, Section 5 of the OVAT Act, read with Rule 5.2 of the OVAT rules. Full stop. Paragraph. This court is unable to agree with the conclusion reached by the CST in the impugned order in the above regard. Full stop. Further, there is no answer to the contention raised by the appellant, by the petitioner SSC, that they said notification dated 5th June 2018 was in fact never gazetted. Full stop. An RTI application filed by the petitioner received a reply in reply to an application filed by the petitioner under the RTI Act on this specific aspect. The reply received from the department. Where is that? Which page is that?
No, page 138 notes. Dated
was that although the notification had been sent to the Director Printing Stationery and Publication, open quotation, the copy of the Gazette has not yet been transmitted by the Director, Printing, Stationery and Publication. Full stop, unquote. The observation of the CST in the impugned order that the additional CST at the time when the suo motu revisional order was passed on 6/12, right?
No, it's 6/12.
6/12, 6th December 2018 was still exercising the powers of the JCST is also not factually correct. Full stop. The notification
at page 139.
139, is it?
Minutes. Serial number 1.
Yeah. Notification promoting the JCST as additional CST and posting him on promotion was issued on 2nd May 2018 itself. So therefore, at the time when the impugned suo motu revisional power was passed by the additional CST, he was certainly functioning as additional CST and not as JCST. Paragraph. Even in terms of the notification dated 5th June 2018, the additional CST could have exercised the suo motu revisional power only if the order under revision was passed by the JCST or a deputy CST. To stop, admittedly, in the present case, it is the STO who has passed the assessment order under Section 42 of the OVAT Act, which was sought to be revised by the additional CST. So therefore, even in terms of the notification dated 5th June 2018, the additional CST lacked the jurisdiction to revise the order of the assessing authority. Paragraph. For all of the aforementioned reasons, the court is of the view that the suo motu revisional power passed by the additional CST on 6/12/2018 was entirely without jurisdiction and beyond the powers of the additional CST. Full stop. Consequently, the suo motu revisional order and the impugned order of the CST affirming it in appeal are hereby set aside. Paragraph. Since the suo motu revisional order has itself been set aside by this court, the consequential demand worked by the assessing authority, which has been challenged in the companion writ petition civil 22064 of 2019, is a computation order dated 17/9/2019, which has been challenged in writ petition civil 22064 of 2019, is also hereby quashed. Paragraph. Both writ petitions are accordingly allowed. No other systems.
Oblations.
Supplemental list item number 14.
None appears.
Item 15, not placed.
Dismissed as not placed.
Item number 16.
16, my lords, infructuous, my lord.
Dismissed as infructuous.
Item 17.
17, Lord. Here there was short supply of CS liquor, and pursuant to that, demand notice has been issued, but it is covered by Lordship's this on court judgment. Here, my lord, the paragraph page 4, this on court has held that the demand is not to be waived because there is short supply stocks. And annex 2, my lord, I have given. There is a short supply by the State Beverage Corporation for an entire year.
No,
Annex
but
to
you
page
want a separate order to be passed, the same order to be passed.
Lordship may direct to consider that on in accordance with that order.
All right. Yes, same order.
17. Na?
Yes, 17.
Item number 18.
None appears dismissed.
Item number 19.
19 my lord to become infructuous.
Dismissed as infructuous.
Item number 20.
20 my lord, first item permitted to withdraw my lord.
Dismissed as withdrawn.
Connected matter also, my lord, not pressed.
Dismissed as not pressed. Second matter.
Item number 21.
21 can be taken up tomorrow because the order and the challenge also filed a separate writ petition, WPC 16862 of 2022. It is fixed to tomorrow, my lord.
All right, list tomorrow.
16862.
If it's there, it will be
Yes.
there. So, all right.
Item 22.
None appears dismissed.
Item number 23.
You are for the respondent.
But we've not been served a copy, so we don't know why this.
Anyway, so nobody's appearing. None appears for the appellate. Dismissed.
Only our presence may be recorded.
Yes, yes, of course.
Item 24.
Delay.
420 days.
Sorry?
420 days delay, but the
Oh, I see.
only problem is that Accountant General has read an objection. He cannot be granted final pension in view of a vigilance case pending. For that reason, this review has been filed.
The question opens up. Certified copy period is excluded. The SR says 89 days.
89. So, only Lordship said that on the submission of national government advocate, that matter has been disposed of. Admittedly, there is a vigilance case was pending.
But by now he'll be retired, sir.
She has retired. That
Then we leave it open. You say
we have given him
the
provisional
delay is
pension.
condoned. You say review petition. The court is not inclined to review the order. However, it's clarified that the decision of the review will be confined to the facts, confined to the facts of the case, confined to the peculiar facts of the case, and will not constitute a precedent. And that writ petition, you say nothing needs to be passed. That MC 14265 is dismissed in that companion writ petition.
Item 25.
None appears dismissed.
Item number 26.
26, your lordships, that day actually 3 matters were listed. OTPL 2, 3 and 4. 2, 3 had that COD issue. They are all actually arising out of the same question of law. But the 4th one was actually disposed of not on the ground of COD. So we had to bring it to your lordship's notice. Of course, your lordships have remanded all the 3 matters. And in the, I think the merit of the matter, your lordships, it still can be remanded because the judgments we relied upon have not been taken note of, and the judgment which the tribunal relied upon is actually factually inapplicable. So but I had to bring this to your lordship's notice. It's a mistake on our part.
It is now pointed out that one of the appeals disposed of with this court's order dated 30th November 2022, namely OT appeal number 4 of 2014, had not been disposed of by the Customs, Excise and Service Tax Appellate Tribunal Kolkata bracket Sistat on the ground of failure to produce the clearance from the Committee on Disputes bracket COD, but on merits, is it?
Merits.
But on merits. Full stop. Paragraph, however, it is noticed that the judgment of the Sistat, even in that appeal, would anyway have to be set aside and the matter remanded to the Sistat for a fresh hearing. So accordingly, while maintaining the directions issued in para 3 of the order dated 30th November 2022, the court is inclined to modify the said order by altering para 1 as under, then we reproduce open quotation 1, 2 of these 3 appeals, that is OTAPL numbers 2 and 3 of 2014, have been directed against the common order. And that whole para you reproduce, full stop. As far as the third appeal, OTAPL 4 of 2014 is concerned, it has been dismissed on merits by the Sistat. Full stop. Then you say further, para 3 of the said order shall be corrected as under. Then open quotation para 3, in the changed scenario, the impugned orders of the Sistat, insofar as it concerns OTAPL numbers 2 and 3 of 2014, cannot be sustained and is hereby set aside. And then reproduce the whole thing accordingly, full stop. As far as the third appeal, OTAPL 4 of 2014 is concerned, in as far as it does not consider the case law cited by the appellant, the court is of the view that it requires to be reconsidered by the Sistat. So then reproduce the remaining part of para 3 as it. Paragraph, the corrected order now be uploaded afresh by the registry and the earlier order be taken down. Yeah, it's disposed of.
Item number 27.
27, no instructions. No instructions in this matter. Item 27.
Dismissed, no instructions. Dismissed for no.
Item 28.
28, my lord. State's revision. Question of law is at page 18, my lord. Whether on the facts and in the circumstances of the case, fly as brick would fall within the scope of entry 12 of the part 1 of schedule appended to the Odisha Entry Tax Act 99, namely roofing tiles. Serial part 12.
It's not answered already. There's a judgment on this.
No, my lord. This has not been answered.
I think so. What's the tax effect here?
5,33,000. So.
All right. Notice returnable. April 13th.
Item 29.
None appears dismissed.
Item 30.
Item 30, my lord, the office note of says that on 13th 9 2017, the same APL was allowed by this honorable court, my lord. By the honorable single judge, my lord. Thirteen 9 2017. Same APL number 341 2017 was allowed.
No, it's not correct. Never been listed once.
But our office note says that.
Whose office?
Our office note, the petition.
Your office note can say anything, sir. We are not bound by your office note. You say no steps have been taken for continuation of delay.
My lord, miscase has been filed, my lord.
There's a delay of 6 years, 247 days.
My lord, miscase
Filing
has
the
been filed, my lord. 195 of 2017.
All right. You just put down 195 2017. There's an inordinate delay of 6 years and 241 days in filing the present CMAPL. The reasons stated are totally insufficient and unconvincing. Consequently, the miscase is dismissed. The CMAPL is dismissed. All right.
Item number 31.
Bona fide mistake of the advocate, my lord. Dismissed, but person concerned is suffering recurring loss will have effect on his pension and also huge recovery.
It's all for so many years, sir.
Well, in the meantime, recovery has been not been affected, and
very happy then.
Yeah, and also there will be kindly see the married person, my lord. How much they are going to recover from a retired person?
No, but if they're not done anything so far, then they will not do anything so far.
My lord,
you say nothing has been recovered so far.
No, nothing. But question is that there is a because of matter is pending. But at any time they can do it.
No, it is not pending. It was dismissed long ago. This is for restoration.
But question, but about pension, my lord?
Whatever.
Pension will have a.
This was dismissed long ago.
Just for a moment, kindly see writ petition number annexure, page 20. They are going to recover.
So when was the writ petition?
And my lord, the only point of law that I have cited Muthuswamy, legal opinion, they disregarded it. The learned tribunal was guided by that. That's the only point.
When was the writ petition dismissed?
Dismissed, my lord, on 7/7/2017.
So
and
for the last 5 years, nothing.
And filed on 26/7/2017.
So nothing recovered for the last 5 years.
It might have been recovered. On that point, as on date, I don't have instructions. So
that's the best we, sir.
So far, the pension effect on pension.
The problem is we listed it on our own. Suppose this had not been listed today, you would have been very happy.
My lord's magnanimity. That at least it comes
not magnanimity, nuisance. But for all of you, this is becoming a nuisance. You people had forgotten about this petition. Unnecessarily, we reminded you.
Only humble submission, let the matter come to the board.
You had forgotten this long ago, sir.
Tomorrow I am ready to.
You are forgotten. Your client had forgotten. Unnecessarily, we have listed.
But a old man.
That's why let him be peaceful, sir. We are not disturbing his peace.
His recovery.
Nothing happened, sir.
Sustaining effect on the pension.
Nothing happened. His petition was dismissed.
His
petition was dismissed 5 years ago. Nothing happened.
Every year, every month from 93 onwards, pension. Pension is recurring cause of action.
All right. No merits in this application.
Well, only humble submission, let one hearing be given. And that did authorize the lifelong this.
Nothing is happening. So if it had not listed it today, nothing would have happened.
Kindly see the annexure 5 of the government the writ petition.
Yes.
How much they are going to recover?
Right.
And what is the loss on my pension?
Very good. Very good. All right. Yes.
Will it be restored, my lord?
All right. Yes.
32, no instruction.
No instructions dismissed. All right.
Item 33.
May I please? My lord, in this case, my lord.
Limitation.
In this case, my lord, this matter relating the OGLS matter, my lord. My lord, only 7 days time, my lord, prefer 7 days time for a removal of defects.
Not necessary, sir. We can carry on with the matter now. Already 5 years.
My lord, the civil, the petitioners are still now continue their peaceful possession over the suit land.
So let them be, sir. You be peaceful, we'll also be peaceful. Why bother about all this, correct?
The civil right.
Let's not bother about all this, sir. Everybody can continue peacefully wherever they are. All right.
My lord, only 7 days time. 7 days time. I'll only prefer 7 days.
Not necessary. Not necessary. Not necessary, sir. Not.
My lord, still now continue their peaceful possession over the suit land, my lord.
Correct. All right.
And the lease has been granted in their favor for a homestead purpose.
All right. Yes.
Item number 4.
7 days time to remove the defects.
Not necessary, sir. It's all 4 years old, huh? Yes. What's the main matter? What?
It's the regarding a wrong placement of the gradation list has been challenged.
Now, all that is all best is to leave it all be, sir. See, everybody wants peace, happiness. They've forgotten that they filed these kind of petitions. You forgot you filed a restoration application. So best is to keep it like that only. Note in the present application is dismissed as such. You see, steps were not taken for filing application for delay for over 4 years. Defects not removed. Even otherwise on merits, the court is not inclined to interfere. The application is dismissed.
Item note 35.
And item note 35 and 36. In the both these appeals, I challenge the annexure 1. I'll kindly to turn to page 2020.
No, defects not removed, Mr.
Per minute, madam. I'll turn to page 21. In this case, the appeal of the petition
for 4 years is not defects.
But the defect is 180 rupees I have to pay. But the kindly see.
You have not found. See, the point is CSE is so poor.
No, madam.
And the council is poorer. Mr. Sarangi is so poor that 200 rupees court fee is not able to pay.
No, madam.
For 4 years. 4 years. See, we deeply sympathize with you, sir.
For 1 minute.
Yes.
The tribunal says, can turn to page 21.
Why should we turn to that page, sir?
Kindly see.
We are handicapped, sir. We're not able to move to that page at all.
It says that the entire appeal depends upon the issue to be decided by the Honorable Supreme Court. And that case is pending before the Honorable Supreme Court. That I want to submit.
The appellant has been unable to pay court fee of rupees 188 for over 4 years. And what's the delay?
In course of the delay.
Even the explanation for the delay in filing these appeals is not satisfactory. Consequently, the court does not propose to grant any further indulgence. Both appeals are dismissed for non-prosecution. Right.
One line, but the entire issue revolves around the issue to be decided by the Supreme Court. And that case is still pending.
All right.
Item 35 and 36.
Yeah.
Item note 38.
38 Milord, on behalf of Mr. Mohanty Milord, he has some medical problem today.
What's
so he requested me Milord to pass. 38 Milord, on behalf of Mr. Mohanty Milord.
What's the difficulty?
Milord, he has some medical problem. He has leave.
Or the appellate is stated to be unwell. List on 20th April.
Item note 39.
None appears dismissed.
Item note 40.
40, my lord. States revision, my lord. The question of law is at page 18 of the revision petition. Question A, whether on the facts and in the circumstances of the case, the tribunal is not justified in dismissing the second appeal filed at the behest of the state of Odisha, which is directed against the appellate order, deleting the penalty imposed exercise of power under section
9C.
Yes, my lord.
All right. Notice returnable. What's the penalty amount?
Well,
13th April.
17 lakhs.
All right. Notice returnable 13th April.
Item note 41.
41 also states revision, my lord. The question of law is that
531 days, sir. Delay is 531 days. All right. Inordinate delay of 531 days in filing the revision petition, which has not been properly explained. Leaves law open. The delay is not condoned. The SCRV is dismissed. All right.
Item 42.
42 also state revision, my lord. The question of law is at page 21. Question Roman 1, whether on the facts and in the circumstances of the case, the Odisha Sales Tax Tribunal erred by reducing the imposition of penalty by applying the amended provision in section 43(2) by virtue of Odisha Value Added Tax Amendment Act 2015, which came into force with effect from 1/10/2015 by Finance Department notification number such and such. This question has already been admitted by me.
When is that coming up?
Only one has been admitted, my lord.
Sorry?
Only one item has been regarding this imposition of penalty.
So when is it coming up? No. Give us the date. Which matter and which date? When is it coming up, Mr. Mishra? You're aware?
No, I that day I was before my.
Oh, I see. So we can pass it over. You can find out.
Yes, my lord.
Pass over. All right.
Item 44.
Delay.
Item number 44.
Same. 43.
Yes, my lord.
Pass over. 45 also same.
45, yes, my lord.
Same. All three pass over.
Item 46.
46 and 47 notes, we have instructions to appear in this case notes. Subject to your lordship's kind pleasure, if your lordship will kindly grant us some time, we'll file our appearance memo and also the. I'm sorry, notes.
What's the matter about?
No, it's a tax revision. I do not have the file also because Mr. K.K. Panda, he was the person engaged. Now, the arguing counsel is no more there. He expired in the meantime, Mr. Pati.
We determine the labor and service in accordance.
And I think this has also already been answered in a similar matter where Mr. Anup Mahanti was arguing regarding Hindustan Steel Mills. So,
the request to Mr. Karel and counsel the petitioner list on. Now we'll have to start going to May now. 10th April.
Sorry.
10th April.
I'm sorry for the inconvenience.
10th April. Item 47.
Same.
47.
147. Yeah.
Item 48.
48 also, my lord, one time penalty.
Same.
Yes, my lord.
All right. Pass over. 105 also.
Yes, same.
All right.
Is it that, Mr. Pradhan, is it that Zenith case?
Yes, my lord. Zenith.
Find out.
Yes, my lord, I will.
Item number 50.
Obligement. 14.
Item 50.
50, my lord. It is
coal claim to be input.
Yes,
now
yes,
this is over now.
No, this is pending coal.
No, coal is input.
No.
For generating electrical engineer is over. We have answered it. I've given which is the judgment? Nalco. Yeah.
Input. Consumables. Bad.
Yes.
Bad. Bad.
Let it.
So that question is also here, my lord.
No, but I think this has been answered, sir. Coal as input for generating electricity, that's been answered.
Consumables.
Find out. I think
ACC cement. I think ACC cement.
Mr. Siddharth Rai was arguing that case.
Coal is a raw material or input for the clinker.
That's right. Clinker.
My lord has decided that.
Correct. That's what. So you find out what matter that is.
Associated cement case. Associated cement case.
Just ask Mr. Rai's associate. He'll know.
Your Lordship, that order is with me. Your Lordship.
So we'll pass it over. Anyway, you're passing over for several others. All right. Yeah. Pass over. All right.
Item number 51.
51 was regarding one-time penalty. Regarding one-time penalty, my lord.
I see. All right.
Item 52.
So this is 9C. This
My lord.
so notice returnable 10th April 113. That IA is allowed dispensing.
Item 53.
53 also, my lord, one time penalty, my lord.
That pass over.
Item 54.
54, my lord.
Suppression.
Yes,
Without
my
any
lord.
determination. I think
Deletion of announcement, my lord.
yeah, suppression is over. You see, in view of the decision, which is that judgment of ours or that suppression thing without inquiry? I think it was Justice Jagavant's house matter. Is anyone here from that office? No. All right. You view the decision of this court in Dash versus Dash, where it has been held that there cannot be an assumption regarding suppression of sales without an inquiry. The court is not inclined to entertain the present revision petition on behalf of the state. The revision petition is dismissed. This is 115. The delay is condoned. How much was the delay?
123 days.
See, even on ground of delay, which since it is not satisfactorily explained, the court is not inclined to entertain this. Right. Dispense is allowed.
Item 55.
Same, my lord. Here.
Same meaning suppression.
Yes, my lord.
Same order in 55.
54. Item 56.
May I please, Your Lord? The date 27, my lord, due to my tooth problem, I have extracted tooth from my right jaw. I could not appear for this court. It is dismissed for default on that date.
So 27th October is problem.
Well, due to my health problem, I could not come here. No, otherwise, 20, 20, 30, I am always there. Only one date I am not there, my lord, due to this reason. I have never tell any lie to the court, my lord. Due to the extraction of my tooth and due to tooth problem, I could not able to appear before my lord. Otherwise, there is no intention. Every time I appear up to 27th regularly. I have also filed counter, rejoinder, everything I have filed in this case, my lord.
So one thing I just wanted to share with you, what we used to do as lawyers. It's all up to you. I mean, you have different practices, you have different traditions. And you have now spent how many? 25 years in the bar, sir?
My lord.
What I used to do is always request a junior colleague, courtesy for the court, nothing else. Even if I'm very seriously ill, I will request a junior colleague saying, when the matter is called out, kindly be present and request the court for an adjournment, saying counsel is unwell. Even today, we had many in such instances where a junior came, my son is unwell, we have adjourned it. All right.
Well,
that's the least courtesy. You're a lawyer of 25 years standing, 30 years standing.
My junior is with me on that date when I extracted my tooth in the PKSAU clinic, my lord.
So problem is, sir, you use your juniors for all this. He used to, if I had to go to the dentist, I will not ask my junior to come to the dentist with me.
No, he's with
junior will be for the court. For dentist, I will take somebody from my house. I will not take the junior for that. That is all. This is again tradition of the bar. I don't want to interfere with this tradition of the bar. But this is the courtesy that one has to extend court. When you're unwell, you send a junior colleague and you request the court for an adjournment. You don't stay absent. Don't stay absent. If it was not 27th October, I will not even be having this dialogue with you.
Well, I know very well that. So that is that date I am facing this type of problem. On hours I am not there, always with the court. On hours there is a strike will going on. But all the 27th after, I am always.
And this is hybrid mode. This is hybrid mode. Even from your, some courts may have objected if you are appearing from your clinic also. I would not have objected even if you're appearing from clinic.
So kindly condone, madam.
Yes, we have not. From Puri, Mr. Chimanka appeared from under a tree.
Under tree.
He was on a divine mission. So we did not mind it.
Maybe condone, man. I may be excused for this.
Let's see. We'll see how many such petitions are there. It's main matter about. What is the main matter about 148?
When issue is 148, the assessing officer who has issued the notice, he has not the assessing officer and making the assessment under section 147, madam. Notice has been issued by some range and assessment made by some other range, madam. So when the very jurisdiction has been transferred to the central circle after 140 notice has been issued. So satisfaction is made by somebody else and assessment made by somebody else. So that's why I filed this petition. Your lordship, please to admit and give counter and give me also interim protection, my lord. And a similar matter is posted on the 1st February 2022, my lord. In case of the one of the director whose house and whose business premises has been served on for some date. And similar issue before my lords to decided on 1st February 2022, my lord.
2023?
2023, madam.
Right. Just list this on 23. 1st February 23. Not passing any other order. All right.
And order to be original order to be
list on. Let's see what happens.
No,
List on
original
1st February 23. All right.
Item 57.
Obliged.
No instruction.
No instructions dismissed.
Item 58.
State, my lord. Here I have challenged the inaction of the opposite in evicting the opposite party number 1 and 2. Lordship may come to page for annexure 14, page 39. Upon receipt of the forwarded grievance petition, it was sent to the revenue supervisor for field inquiry. As per the report of the revenue supervisor, the plot number 32 in Khata number 118 has been used as public road, but in the year 2015,
who's the encroacher, sir?
Lordship, here Purna Chandra Shetty and Shubhankar Mahanti, who has been implemented as opposite party number 1 and 2.
All right, the petitioner's representation. Which is your date?
It's not the representation, my lord. It's here, my lord. Rather than going for a OPL proceeding under section 7, they have the Tahsildar who has been implemented as OP number 3 has asked the revenue inspector to initiate the encroachment case. Under 7, lordship,
that is your prayer, sir. Come to your prayer clause.
Prayer, lordship, I am only challenging the inaction of the.
So if it is inaction, you let them treat this as a representation and take action. So. If you want to withdraw this and make a proper representation, use the counsel of petitioner.
My lord, I have already made several representations.
Give us one copy of one representation. And when did you last make it?
15/12/2020.
Make a fresh one, sir. Counsel the petitioner seeks leave to withdraw the petition with the liberty to make a fresh representation to the authorities after following up this representation to seek appropriate remedies in accordance with law. The petition is disposed of.
Item number 59.
59, my lord. Annexure 4 is my representation pending before OP2 for due to unauthorized occupation by the private opposition 7, my lord. By the government land has been encroached by the private opposition 7, my lord. Annexure 4 is pending before OP2, my lord.
There is no.
There's proof of that.
Proof of delivery.
Page 13, my lord.
Proof
of delivery.
Proof, sir.
Sorry, smile. Adjourn next.
permitting the petitioner to make a fresh representation in accordance with law. To the authorities and after following upon such representation to seek appropriate remedies in accordance with law, the petition is disposed of. All right.
Item number 60.
Remove within 1 week.
The prayer is with regard to conducting investigation by CBI. He's alleging some misappropriation. Similar matters, my lords, are referring to the
Lokayukta. Best is to go to Lokayukta, permitting the petitioners to approach the Lokayukta for the grievance made in the present petition. It's disposed of. All right.
Item 61.
My lord, the villagers, my lord, of Nuaga village under the district of Kandhamar, my lord, they are, my lord, for coming up this CRPF camp, my lord, new camp. They are saying that they are not opposing the establishment of the camp. They are only saying that can it be shifted to another nearer place because it is closely to the vicinity of their habitation, my lord. That is why, my lord, by Annexure 2, they have already represented to the collector, to the opposite party number 4, my lord. Let the collector take on the representation, my lord, page 55.
I think it is CRPF camp. So
yes, they are saying that
union government is to take a call on this.
Yes. No, the collector has given the land, my lord. What they are doing is
given the land to them, but so far as establishment of unit is concerned, it is their unit.
In fact, you have to make a representation to the CRPF itself.
Yes.
You make a proper representation, permitting the petitioner to make a proper representation to the concerned authority. And after following up with such representation to seek appropriate remedies in accordance with law, the petition is disposed of. All right.
Item number 62.
All right.
62, sir.
62 means 10 days time will be granted to remove the defects.
All right. Defects we removed within.
Lord, I am appearing. Lord, file memo appears.
Left thereafter. All right.
Item 63.
May I please, your lordship? My lord, here, petitioner's proposal for on-staff license was rejected by the government, and very same day he filed a representation for reconsideration. By the Annexure 7, the government has been pleased to direct the commission to make a physical inquiry and submit a factual report. On turn, my lord, by the Annexure 8, that at page 34, the commission has directed the collector of the concerned district to make an inquiry and submit a report that is still pending before the collector without any effective steps. I pray that Annexure 8 may be disposed, collector may be directed to expedite the inquiry and submit it.
It is there with the collector.
Only
He will
ballot-
do it. Only he wants a time-bound direction.
In a time-bound direction only. Because lordship knows 31st is my approach.
Then again, it will go to excise commissioner. There, the file will be there, and he will again file a petition.
Only innocuous.
You do.
File movement petition.
File movement. Yes.
Lordship knows it is 31st is approaching that.
Okay.
You're making High Court judges do a lot of other work also.
No, my
But
lord.
in some time, what I intend to submit before your lord, in some time, these courts order become boomerang for them. Because in normal course, it may happen tomorrow. But your lordship is fixing, let us assume for 30 days.
It is a destiny of a client, my lord.
That may. So once they get the High Court's order, they will say, no, we are entitled to keep it for another.
That Annexure 8 has to be considered by the collector. Lordship may fix a date so that.
The petitioner states that he will be satisfied if a direction is issued to the collector. Which place is this? Cuttack. Kandhamal. If a decision is taken on the
Annexure 8,
on the letter written to him by the Excise Deputy Commissioner (CD) Cuttack on 16 November 2022 (Annexure 8). Accordingly, directions issued to the collector to take a decision on the aforementioned request, if not already taken, not later than 31st January,
my lord,
2023. And full stop. No further directions are called for. A copy of this order be sent to the collector and district magistrate. Nabarangpur, it says here. Not Kandhamal, Nabarangpur, sir.
Nabarangpur, collector Nabarangpur.
Nabarangpur. You'll send it to the wrong place.
No, no. Navarangur.
Then one more petition. Petition is disposed. Copy of this order we sent to the collector Nabarangpur. All right.
Obliged.
Item number 64.
I am for the opposite party, my lord.
Right.
Earlier direction given by this honorable court has been complied with now. And his representation has been considered and was rejected.
All right. None appears dismissed.
Item 65.
My lord, Honorable Justice Raman is concerned. So,
All
matter
right.
may kindly
List before a bench of which Justice Raman is not a member. On Friday, 27 January.
Item number 66. Supplementary list item 66.
All disposed of cases. What is this? Endorsement. What is the endorsement?
Your Lordship.
Aye.
The Lordship is taking up item 66.
That's right. This was before another bench. I think one of them recused, one of the judges.
Sorry, my lord.
This was before a different bench and one of the judges recused, and so it has come to us.
Yes.
Notice is not gone on this yet.
Notice has been issued.
Counter has also been filed.
Yes, my lord. My lord, there are two writ petitions.
No, we're looking then at the opposite party. Who's for the opposite side?
The opposite side is the Water Resources Department.
That's right. Anyone from the state?
Look, they have filed a writ petition challenging the award after almost about 550 days from the date of notification of that award.
Oh, I see.
We filed a writ petition earlier, and in that writ petition, they filed a counter stating that we have obtained the concurrence of the Law Department. The concurrence of the Finance Department is awaited. And now they, after about 500, then they filed the writ petition.
Is there.
And these workmen, if your lordship will look at, but in fact, before the only objection in the award was that at that time they were retrenched from service and therefore they were not considered. But subsequently they were reinstated by an order of the tribunal. They came to you before your lordships, that was dismissed. They went to the Supreme Court, that was dismissed, the SLP.
No, but this is just for implementation of the award.
Yes, my lord. There are two writ petitions. One is implementation, the other filed by the state after a delay, almost
challenging the award.
Challenging the award.
So let's take up their petition first.
Very well.
What's the challenge to the award, sir?
This matter, your lordship, see my counter.
No. 17585, your petition. The companion petition.
17585.
If that petition goes, then orders will have to be passed in the first one automatically for implementation.
Sorry, my lord, that.
No, para 12 is your explanation of the delay. That's not satisfactory at all. You said just take this petition, 17585 of 2021. This is a petition by the Irrigation Department challenging an award dated 18 January 2020 passed by the Industrial Tribunal Bhubaneswar in IDA case number 28 of 2017. Full stop. There's obviously a delay of more than 1.5 years in filing the present petition. The date of filing of which is shown as 4th June 2021. Paragraph. In order to explain the delay in filing the present petition, it is stated in para 12 of the petition is under. Take from page 11, para 12. The above explanation is wholly unsatisfactory. Stop. Even in the petition of Article 227 of Constitution, sufficient reasonable explanations to be offered for the delay in approaching the court. The aforementioned explanation is hardly sufficient, not convincing at all. The Supreme Court has, in Living Media India Limited and State of Madhya Pradesh's Berula, not accepted the above type of an explanation for delay in the state filing petitions, appeals, etc. Consequently, the court is not satisfied that a reasonable explanation is offered for the inordinate delay in referring the presented petition. It is accordingly dismissed. In 29186 of 2020, the prayer in the present petition by the workmen is for directions to the opposite party management to implement the award dated 18 January 2020. The challenge to which, on behalf of the management, has been negatived by this court today by a separate order dismissing the management's writ petition, Civil 17585/2021, paragraph. Consequently, a direction is issued to the management to now implement the said award dated 18 January 2020, not later than 12 weeks from today. If any failure to adhere to this direction, it will be open to the workmen to seek appropriate remedies in accordance with it.
Very grateful, my lord.
Very right.
Item number 67.
67, pursuant to Lordship's last order, my lord, we have filed 3 affidavits. And 2 affidavits. Yesterday, I had filed 1 affidavit, and today we are filing another 2 affidavits. I sought a copy on my lord and friend, my lord.
Yes.
With the amicus curiae in this matter, my lord.
So may I show, my lord, all those affidavits that I rely on. My lord, may I kindly see order number 12, dated 23rd August 2021.
Yes.
Now, if my lord would see the order under the heading of DGROs,
yes,
my lord had interpreted that all 4 benefits have to come under the scheme. I'll just show that para 2 of that order.
Yes.
Now, inadvertently, that maintainability benefit, that last portion, that should be maternity benefit.
All right.
That's a
maternity benefit program. Sorry.
But instead of what I want to submit, my lords, this order is yet to be implemented by them. And paragraph 4, I specifically rely on para 4 of that order. If I just place that, it is directed that the state government will place before the court by way of an affidavit to be filed at least 1 week prior to the next date, details of social audit conducted for implementation of all the schemes, not limited to TPDS. The meetings held as far as social audit should be videographed and uploaded in the website of State Food Commission, since this will ensure greater transparency in the conduct of such exercise and serve the public interest in ensuring effective implementation of National Food Security Act. Now, in terms of this order, they have filed the affidavit, my lord may kindly see, dated 19/12/2022, sworn to one Mohammad Kamrul Haq. In that affidavit, if my lord would see how this order and the act has been interpreted, at page 8 of that affidavit. I hope my lord has got that.
No,
it's filed today, I think today or yesterday.
Yesterday it was filed.
I don't think it's here. We don't have that.
Physical set.
We don't have that.
We have filed the e-filing, my lord, yesterday.
I know. So since it's yesterday, it might not have been able to be included.
So may I
have got a copy.
And these are all directions of the last year now, almost one year, 4 months running. All these directions have not been carried out. I'll just show, my lords, how they are interpreting the orders and also the act.
There's a need for a convergence of different departments.
No. May I just show how they are interpreting the orders of this court? If my lords would see page 8, this is dated 15/12/2022. Now, my lord may kindly see. Conducting of social audit on the functioning of fair price shops and TPDS under so-and-so, in inviting reference to this department letter dated so-and-so on the subject, and to say that the Honorable Court in its order dated so-and-so, that portion, my lord, they have put it in bold. Then, my lord's last portion is very important. It is therefore requested to furnish videography of the activities while conducting social audit in at least 3 fair price shops of each district. That means this is turning the entire act, the order on its head. They have completely rewritten the act itself. Now, if my lord sees section 28 of the NFSA Act, it says, conduct of social audit, every local authority or any other authority or body as may be authorized by the state government shall conduct or cause to be conducted periodical social audits on the functioning of fair price shops, TPDS distribution and other welfare schemes. Now, this local authority is defined under section 2(8), which means every panchayat. If my lord would see section 2(8). Section 2(8), local authority includes panchayat, municipality, district board, etc. So now they have completely rewritten the act, the orders of this court. These are all orders passed in August 2021. So apart from this, the data that they are giving in this affidavit, if my lord would see the data at page 7, just one page prior to that, it's all pertaining to 1st April 2020 to 31st March 2021. So now we are almost touching 2023.
Correct.
Page 9 also same error. They have rewritten the act and the orders of this court. Page 9. They want this to be done for 3 fair price shops. So they have completely, my lords, rewritten the orders, and I don't know how they are functioning. So these, and in my convenience note also, I have highlighted this again and again. If my lords would see flag G of my lord's affidavit, I have highlighted this, and past 2 occasions, this court directed that you take note of the convenience note and comply with the orders.
Correct.
So pursuant to these directions, now this affidavit is being filed. They say that they have read the convenience note, but I doubt, my lords. Flag G, it is clearly mentioned. Each of the items I have mentioned it in that note. So my team of associates, they have checked. This videography is not there in the websites. The numbers, which toll-free number.
It is there. Yesterday I checked it up. Videography is there, my lord. I wanted them to be clear videographs. So I told them, please collect all those.
But how can videography confined to fair price shops? See, the whole thing is about schemes.
My lord.
One is the targeted public distribution scheme is one. The midday meal scheme is the second. ICDS is the third. MBP is the fourth. So all schemes have to be audited.
Therefore, what I pray, my lord, there must be a convergence of all those departments. Because otherwise, if all these department, WCD department is involved, Panchayat Raj department is involved.
No, but is there a prohibition issued by this court? This department should not meet?
No, my lord. I had already asked them, these affidavits, what you are filing, these cannot be standalone affidavits.
Not for standalone. It's not even a proper understanding of the act, please.
I have asked them, my lord, Lords may grant me some time. I will file, my lord, a better affidavit.
Lords may kindly see the direction.
The timeline may be fixed by the Honorable Court, my lord.
Which states be videographed in at least 3 fair price shops. From where they are getting this? That means they don't want to comply with these orders. Now they have been requesting for PDDRDs to be their DGROs. Now they are all government officials. They have suo moto. If my lords would see, none of them have taken any suo moto action. So this is if this
that we have notified.
this act is to be self-sufficient. These social audits are meant to be checks and balances. They have not been implementing this, my lords.
What are the other two affidavits about?
Same thing, my lords, may kindly see.
So WCD, Women and Child Welfare Department.
My lords. As an amicus, I can only point out, but my colleagues in the state, they must see that this is implemented.
Para 5 and 6. It is submitted to the Government of India has issued the revised guideline for the scheme Mission Sakhyama Anganwadi and Poshan 2.0, wherein it has been mentioned that social audits shall be undertaken by stakeholders such as Poshan Panchayat, Mothers Group, VH SNCs, and direct feedback shall also be obtained from those who have availed the service under the scheme. It is amply submitted that the THR distribution under the SNP to eligible beneficiary is being done at Anganwadi centers in the village in the presence of the Janch Committee and Mothers Committee.
What is THR, sir?
THR is, my lord,
take home
ration.
Take home rice.
Take home ration.
Take home ration. They supervise the distribution of ration.
No. What is SNP?
Supplementary nutritional program. They supervise the distribution of the ration concurrently. Besides direct feedback based on governance model, Mo Sarkar is working in the Women and Child Development Department. Direct feedback is being collected from various beneficiaries under the ICDS and Mamta scheme on a daily basis about the benefits entitlement of the scheme, also about any irregularities therein, if any, and immediate corrective measures are being taken. That the department has developed a paperless online system of transfer of benefits under the Mamta scheme directly into the bank account of the beneficiary in direct benefit scheme board, which helps them in seamless delivery of services. Beneficiaries can also be directly applied for the entitlement. The list of Mamata beneficiaries are also being displayed in the Anganwadi centers to seek objection. The payment to the eligible beneficiaries is being done through the centralized bulk disbursement using IFMS system of the finance department. Additionally, a state help desk number 181 is functioning to address the grievances of relating to Mamta scheme. The department is also developing modalities for regular social audits in line with the revised guideline under Sakhyam Anganwadi and Poshan 2.0 management.
What is it saying? This affidavit is not giving us any data at all.
My lord,
just broad things about what the scheme is. No data, no information of any audit conducted.
Therefore, what I'm, my lord, requesting your lordship may kindly grant me some time so that all the departments those who are involved in the social audit process, because I have gone through all these orders of your lordship, my lord, they have to sit together to take a call on this, my lord. Lordship may grant me some time, I'll be able to file a better affidavit, my lord.
Three affidavits have been filed on behalf of the state. The first is an affidavit dated 19 December 2022 by the Special Secretary to the Government, Food Supplies and Consumer Welfare Department, where on the specific aspect of conduct of social audit, it is stated that the social audit of the functioning of all fair price shops (FPS) under the targeted public distribution system (TPDS) in terms of the National Food Security Act 2013 (FSA) has been completed in 30 districts during the financial year 2021-22 by the Odisha Society for Social Audit Accountability and Transparency (OSSAAT) Panchayati Raj and Drinking Water Department. Paragraph. As regards the videography of these social audit meetings and uploading of it in the website of the Orissa State Food Commission, bracket OSFC, a copy of a instruction issued on 20th September 2021 and 15th December 2022 has been enclosed. Paragraph. At this stage, it's the attention of the court is drawn by the amicus curiae to the specific directions issued on 23rd August 2021, where the court had required the government to place before it, by way of an affidavit, open quotation, details of the social audit conducted for implementation of all the schemes not limited to TPDS, unquote. It was the videography of such meetings held as part of the social audit had to be uploaded on the website of the SFC. Stop. The court specified in the said order that the social audit would not be confined to the entitlements under the TPDS, but other schemes including the midday meal scheme, the integrated child development scheme, bracket ICDS, and the maternity benefit program, bracket MBP, as well as any other scheme for implementation of the NFSA. So this flowed from a reading of, section 28 of the NFSA, read with Rule 8, bracket 1 and Rule 9, bracket 3 of the Odisha State Food Security, bracket Targeted Public Distribution System, bracket Rules 2020, which also delineates the powers of the District Grievance Redressal Officer, bracket DGRO, bracket full stop. The court, however, finds that the instructions now issued by the government to the director OSSAAT is for furnishing videography of the conduct of social audit, open quotation, in at least 3 fair price shops of each district, unquote. Full stop. This is an incorrect understanding of not only the scope of the NFSA and the rules thereunder, but also of the specific direction issued by this court on 23rd August 2021. So in other words, the social audit was not meant to be confined to FPSs, and that to only 3 of them, but to the actual implementation of the schemes, of all the schemes referred to in the court's order dated 23rd August 2021 in all the districts in Odisha. Paragraph. Mr. Tripathi, learned government advocate, volunteers that a proper exercise will now be undertaken of conducting social audits strictly in terms of the NFSA and the rules thereunder, including the rules referred to by the court in its order dated 23rd August 2021. Paragraph. It is pointed out by Mr. Mishra, learned amicus curiae, that under section 28, bracket 1 of the NFSA, the social audit had to be at the instance of open quotation local open quotation local authority, unquote, which has been defined under section 2, bracket 8 of the NFSA. To include open quotation panchayat, municipality, district board, and where panchayats do not exist, the village council or committee. Full stop. it must be ensured that these provisions are complied with. And the directions issued by this court on 23rd August 2021 must be adhered to in letter and spirit. Full stop. Paragraph. The separate affidavits filed by the Additional Secretary in the Women and Child Development Department and the Joint Secretary in the Review Department also proceed on the basis as if social audit is meant to be only for the FPSs. Full stop. They do not give any particulars of the actual audit of implementation of the various schemes referred to by this court in its order dated 23rd August 2021. Paragraph. The directions issued by this court on 23rd August 2021 are again reiterated. And a direction is issued that affidavits by way of compliance in light of the directions issued on 23rd August 2021, including the directions issued in the present order, should be placed before the court by way of affidavits of the Special Secretary to the Government, Food Supplies and Consumer Welfare Department, Orissa, as well as the WCD Department and PR and DW departments at least 1 week prior to the next date. What are the other directions?
Yes, my lords, may kindly see my note at flag G, page number 2, report of the committee. Now, in terms of the order dated 23rd August 2021, a committee was constituted. Para 7 of the order, my lord had directed for constitution of a committee. Committee has been constituted and the recommendation I have listed out. So those, let them show point-wise how these recommendations have been implemented by them. It's their committee.
The 5-member committee.
Yes. So that committee has given a list of recommendations. So what they have done, that they should list out. Then,
where is that committee's recommendations? That's annex of E1, is it?
Yes, ma'am.
All right. The above affidavits will also indicate the status of compliance with the directions issued by the 5-member committee constituted by the WCD department. In terms of the order dated 23rd August 2021, passed by this court. Anything else?
The directions, if my lord wants, they are there in the
no, but let them, the copy of the directions of the said committee are at annex E bracket oblique 1. Sorry, is it E bracket 1? Yeah. To the counter affidavit dated E by 1 is the directions, right?
My lord, E by 1. And the relevant portion is at page 21 of that document.
5th January 2022.
Conclusion, under the heading of conclusion, it is there.
WCD department in this matter.
Now, the other issue is regarding this toll-free number. Toll-free numbers we have been trying also. I think
toll-free number is working. Yesterday, I myself checked it up. The toll-free number was working.
No,
I checked it up.
All right.
It's again the same issue. These 4 schemes are not covered. It's only just.
So that is what I prayed before this honorable court is the convergence of all those departments so that they will be able to understand.
You see, all the above departments will hold periodic meetings to ensure that all the directions of this court issued earlier and today are strictly complied with. A complete set of the videographs of the social audit hereafter to be conducted be shared with the amicus curiae, who can then view them and make appropriate submissions on the next date before this court. Paragraph, a copy of this order be sent to the secretaries, special secretary,
all those departments of what, special secretary, food and civil supply, my lord.
Food supplies and consumer welfare department, the additional secretary, WCD department, and the joint secretary, PR and DW departments, both with compliance.
We fix a short date.
Not too short, because otherwise nothing will happen.
In fact, Mr. Tripathi, if he wants, he can get all this.
I am trying, my lord.
I think 13th April will be too late, is it? All right. March, we'll have a date in early March then.
March, my lord.
All right. All right. 1st March at 2 p.m.
1st March.
2 p.m.
We are all great.
Oh, this is another matter. It's one. All great. Yeah. What was it? 2nd March. 2nd March.
We are all grateful.
Item number 68.
May I please, your lordship? This PIL has been filed regarding the road that is being built and used by Vedanta Limited besides the high school, and it is being inconvenience to the children that they're studying in school, my lord. Last time it was directed the state to file the counter, but till
What
now
happened,
they have
Mr.
not filed.
Private opposite party has already filed, but we have not filed. Another date maybe.
Last opportunity to the state to file its reply within
Opposite party number 4 and 5 have filed the counter, my lord.
8 weeks. Resorted that to finish be filed the next day. 2nd March.
Yes.
Much obliged, ma'am.
Item number 69.
May I please, lordships? Lordship, in this matter, the issue is levy of entry tax on sand and chips. A similar matter has been posted for hearing on 19th of April, along with WPC number 1856 of 2016.
List on
19th April.
19th April, along with writ petition civil.
1856 of 2016.
All right.
All are similar.
2016. All right.
Item number 70.
Item 70 and 71, your lordship, I'm praying for a passing vote.
All right.
Pardon me, lordships. Interim order to continue.
Interim order to continue.
In all three.
69. Right.
Okay.
Item 72.
My lord, the impugned order I have challenged passed under section 43 of the OVH Act on basis of the AG objection, which is annexed and annexure in annexure 1, page 34, my lord. And it is squarely covered with the case of automobile case, and that is still.
Lord, I have the assessment record. It has not been, no order sheet has been maintained. I need some time, my lord, to verify the written record, my lord, whether there will be.
At the request of counsel of the state, who needs time to verify the original records. List on 17th April, interim order.
Oh, bless you.
Item number 73. Item number 74.
73.
73, yes.
I'm appearing in this case, Milords. Lordship may kindly peruse order dated 14/12/2017, Milords.
Yes.
The brief facts of the case, Milord, is that after a 143 assessment, Milords, I filed an appeal, Milords. Against the CIT appeals order, I moved the appellate tribunal, Milords. In the meantime, the principal commissioner, Milord, he initiates a 263 proceeding, Milords. And the issue is, Milord, whether there'll be interest on NPA amount which was declared NPA, Milords. That was the issue before the tribunal. which is now decided in my favor, my lords. Your lordship, in my favor, my lord, at paragraph 9, my lords. And the same very issue, my lord, was taken up by the principal commissioner also, and he decides against me. So during that interregnum period, my lord, I came up before this honorable court, and the honorable court, my lord, by order dated 14/12/2017, while granting stay of Annexure 5, that's the principal CIT's order, my lords, they have observed, my lord, about the provisions of 263(1)(c, my lords. And they had given liberty to the tribunal, my lord, to proceed, notwithstanding the pendency of the writ petition, my lords. And in the meantime, my lord, the tribunal's order has come, my lords.
So this is all infructuous now.
No, this 263 order has to go, my lords.
No.
Because
every year, my lord, is different.
No, this is the same year. Your lordship may kindly see, this order is 12/13, my lords. And if your lordship would kindly take up Annexure 5, my lords, that is all for the same year, my lords. Annexure 5 at page 39, my lords. The same period, the same issue, my lord. The issue, my lord, Annexure 5 at page 39, your lordship got it, my lords?
Yes,
the
yes.
Period is 12/13, my lords.
Correct.
And if your lordship would kindly see the tribunal's order, my lord, that is also for the same period, my lords. Because and the issues, my lord, has been delineated at page 2, my lords. And the first issue, my lord, is relating to levy of interest on the NPA amount, which has been answered by the tribunal at paragraph 9, my lords. So in my humble submission, in view of the tribunal's decision in my favor, this 263 order has to go, my lords.
Lord, I have filed a counter affidavit declaring through judgment of this. One is Supreme Court, another is Madras High Court. Kindly see my counter. I have filed a counter affidavit. Lord, the Honorable Court, Lord, has granted interim order in view of that 263(1)(c). Lord, a similar issue is pending before the tribunal. Therefore, this Honorable Court has granted stay and liberty has given to proceed the tribunal. Tribunal is now, Lord, passed the order in favor of the assessing. Now, your lordship see, this issue, Lord, has come up before the Supreme Court is not done. Lord, I'm sorry, Lord, I have one copy because he's morning till that will take time. Therefore, I am not prepared this note. But now he is arguing. Even then, Lord, I am ready. Madras High Court clearly stated, Lord, that in the assessment order, if he is not clarify the issue, what is the uncertainty, but by the not accruing the interest in mercantile system, Lord, he has to refer in the assessment order. Your lordship see the assessment order, paragraph in Lord, page 12.
No, but what do you say to his submission that the 263 order has to go now?
No, that is my argument. I am saying, Lord, the tribunal's order, Lord, is against the judgment of the Supreme Court and the Madras High Court.
You have not challenged it.
No, I have to check. Sorry. I have to check that whether I filed the appeal or not. Sorry, Lord. I'm sorry, Lord. I'm checking, Lord. I have to check it, Lord.
Or there's an interim order in your favor.
Yes.
Or you say the request of Mr. TK Sarkar comes to the department. List on.
It doesn't go to
16th March.
Yes.
Interim order
to cut.
March. Obligement.
Item 74.
Well, similar matter regarding levy of interest on input goods, 5th or 2nd February to.
Or list on 2nd.
Item note 75.
List on 2nd February along
2nd February 23.
Along with
the batch of writ application.
No, give us one number, sir.
I'll just.
All right.
Your Lordship, the matter is on behalf of Mr. M.K. Mishra. The matter is infructuous.
All right. 75.
No. 75. I am appearing.
76.
I'm
75 is there.
Not 75 arises out of government land. That demand notice I have given the order. I have corrected also.
All right.
Demand
Same order in
date and
75. 76 dismissed for no instruction. All right.
Item 77.
77 minor covered by Malta.
Pieces.
Not covered.
Pieces.
I am appearing for the opposite party corporation, my lord.
All right.
In this case.
78 not pressed.
78 dismisses not pressed.
Item 79.
79, I am permitted to withdraw, my lord.
Dismiss is withdrawn.
Item number 80.
80, my lord, here the petitioner is filing this writ petition challenging the inaction on the part of the government. The petitioner has deposited the demanded amount. Here he has seeks liberty to
approach the government.
My lord, yesterday's item number 77.
All right, same order. Same order is yesterday 77. All right.
Item number 81.
81, I was also permitted to withdraw.
Dismiss is withdrawn.
Item number 82.
82, my lord, liberty may be granted to file appeal.
All right. Counsel petitioner seeks leave to withdraw all these matters.
Yes, my lord.
Both these matters.
Yes, my lord.
Withdraw this writ petition, liberty to file an appeal as provided in law. If such appeal is filed not later than 6th February, accompanied by an application for condonation of delay, explaining the delay on account of the pendency of the present petition. It will be considered in accordance with law by the appellate authority. The court clarifies it's not expressed in the matter. Is there any interim order here?
No, my lord.
There is an interim order. If the appeal is filed as within the time stipulated, along with an application for interim relief, till such time the appellate authority passes an order thereon, the interim order dated 19 June 2017 of this court will continue. The originals be returned subject to being substituted with the attested photocopies thereafter. Petitions are disposed of as withdrawn with liberty is paid for in the above terms. Both matters.
Item 83.
Obligement.
83.
My lord, demand has been challenged. Before interim order passed, the petitioner has deposited the demanded amount. My lord, here only seeks liberty to approach the government for refund of this amount, my lord.
Why? There was a demand, you have deposited it, why it will be refunded? Or is this, no, that liberty should not be granted, otherwise they will misuse the liberty.
My lord, the demand, illegal demand, my lord.
You have paid it, sir.
That, how can it?
Under duress, for non-renewal of the shop, he has deposited, my lord.
This type of interference is not.
Only seeks liberty to file a representation for refund of the amount.
Where's question, sir?
That how can the court give a liberty that you approach for refund? That means they will think that that is indirectly the court is asking us to refund the. No, they can file, but no observation should be made. That is my responsibility.
File it separately, sir, independent of us.
Yes. Or they file an independent writ petition.
Reserving the right of the petitioner to file, institute separate proceedings as regards refunds. The present petition is disposed of in view of the subsequent. Present petitions are disposed of in view of the subsequent developments.
84. That was 83. 84 tomorrow. Item number 84.
Item 84 is of the year 2016-17, where the theory of interchangeability was very much there.
That is
we have applied for interchangeability. If that's pending with them, if that is considered, then demand will not survive. The interchangeability of 16-17, they should take a decision on that. But she may relegate me back to the commissioner. The interim order is there. Let the commissioner decide it. Because interchangeability is allowed for each one, every license for that year as a whole.
5-6 years back, there is
that's a question where interchangeability is allowed to every licensing. Interchangeability means exchange of BL against LPL. They have allowed it as a matter of principle. So I have applied also for that.
Let him approach the commissioner. Commissioner will take it.
All right. Counsel, the petitioner states that he will withdraw the suspense with liberty to approach the commissioner regarding interchangeability.
Interchangeability.
Consistent with the current policy.
Yes,
not prevailing policy.
Prevalent policy.
Or in terms of the earlier policy.
Right.
So if such application is filed not later than 6th February, then it will be considered on merits by the commissioner after hearing the petitioner, a reasoned order shall be passed within a period of 4 weeks thereafter.
The interim order is there, my lord. Let that continue till disposal of the commissioner.
Till such disposal of the representation, the interim order passed with this court in these petitions will continue.
All these three matters same.
Yes.
Item number 85.
85, I prefer short adjournment for filing of rejoinder.
Rejoinder to file for the next date. List on 6th April.
Supplementary list passed over matter item number 2.
Somebody has to study and come back. No?
I am appearing from the board, my lord. My presence is also.
After lunch. Let's come back after lunch. And they'll be ready with those details also.
You, my lord, I've been engaged in this matter. May I pray, my lord, that the matter come up after a week, my lord?
Mr. Kanungo, we had a not too pleasant sight of one of your juniors coming for this matter without a paper book.
My lord, actually, none of the files have been transferred to us, my lord.
Then you leave it at that, sir. Without, if your engagement without brief, then there's a serious problem, Mr. Kanungo.
No, my lord. So what has happened, my lord? The paper book is with Mr. Das's office, who's become a government advocate.
You best is restore it, sir. We'll dismiss it today for non-prosecution. You restore it. You seem to have a lot of problems. By the time you get the paper book itself, it's going to take time.
No, my lord. We'll get it immediately, my lord.
No. It will happen very quickly once we dismiss it today. Yes. We don't even have the privilege of seeing you, Mr. Kanungo. So we are deprived of that privilege as well. So we are actually in a deep constraint, sir. Without looking at the lawyer, without looking at the paper book in the hand of the lawyer, we have to pass orders. It's a bit difficult for us, sir.
My lord, Friday, my lord. At least Friday, I'll prepare it, my lord.
No, I think your restoration application will now be filed within less than 12 hours. Just watch what happens now. It will happen. It should happen like that, sir. Then you'll immediately go looking for the paper book. You see, the matter was passed over since the lawyer appeared without a paper book, saying that he has been engaged to appear in the matter. The court was surprised that an engagement has been accepted without the lawyer even looking at the papers. We'll stop. After Passover, a senior counsel appeared, purportedly in hybrid mode, but without being visibly present, since the video was switched off. Full stop. The situation was no better since even the senior admitted that he has still not seen even the papers, since no paper book was available. Paragraph, the petition dismissed for non-prosecution with liberty to whoever may be the counsel who will be engaged to revive it once the paper books are available to such counsel. All right.
Deeply obliged. Deeply obliged.
My present paper. Item number 4. Item 4.
Your Lordship, on item number 4, that the appellant is filing the present writ appeal, being aggrieved by an order dated 12/9/2017, passed by the learned single judge, wherein the Honorable single judge was pleased to dismiss the said writ petition in question on merit. In this case, in this matter, what happened is the appellant has been appointed as a personal assistant to registrar from the year 1979 to 1985. Then he got an appointment letter on 8/4/1985 that he has been promoted to the PA of Vice Chancellor. So for 2 years, he has been served as a personal assistant to Vice Chancellor. Then suddenly he got a letter on 9/4/1987 that he has been reversed back to seniors.
Reverted back
to
as
senior superintendent. Sorry, senior stenographer. So and he has been given a lower paycheck of from 10/4/1987 to 28/4/1992. So we are appealing that the previous order has been passed without application of judicious mind and with wrong facts. And
what is the wrong fact, sir? What fact in the impugned order is wrong?
I read out what has been written, but the thing is that
you've not read what is written.
I read that what has been written.
Sorry,
I have read only the words what has been written in the file.
The file. This is a writ appeal, correct?
Yes, sir.
When did you pass out? In
2021 from NLUO.
NLUO?
Yes, sir.
All right. And when did you enroll, sir?
In 2021. So in 2022 December only.
20 December? We are now in 22 December, sir.
Sorry, sir. From after passing out from BLLB, I have enrolled in December 2020. Then I get enrolled into LLM from
No, you enrolled as a lawyer in 2020.
Yes, sir.
2 years ago.
Yes, sir.
Writ appeal means what is it against? What is the writ appeal filed against?
The previous order has been passed.
Previous meaning what? Writ appeal will be filed against what? When somebody has filed a writ appeal, what will be challenged in the writ appeal?
If
you have the paper book with you?
Yes, sir.
Come to the prayer clause, sir. You know where the prayer clause is?
Yes, sir.
Page 15. Read the first prayer.
Prayer number 1, admit the writ appeal and call for the calls and after hearing the parties may allow the writ appeal with a direction to pay the appellant the differential salary in the pay scale of PA to Vice Chancellor at rupees 1,920 only for a period of 10/4/1987 to 28/4/1992 by setting aside the order dated 12/9/2017 passed by the Honorable Single Judge in WPC number 724 of 2029.
Now answer the question. So what is challenged in this writ appeal?
Challenged the judgment of WPC number 728 of 2009.
Very good. What's the date of the judgment?
Date of the judgment, I guess it's 12/9/2017.
Where is it in the paper book?
I guess it's it has been an order copy has been annexed as annexure 1.
Have you read it, sir?
Yes, sir.
What does it say?
Sorry, sir. Sorry, sir. I guess
according to, as I remember that, there is a, the position held by the position held by the appellant is illegal and
No. If you have not read it, you tell us. We have not read it.
I have read it once, but I could not comply.
No, see, fortunately in the court, unlike the exam in the college, here you're not asked to reproduce. Even the best lawyer, suppose I ask him, sir, read section 11 CPC, he will not start saying, he will take CPC, he'll read section 11. Likewise, when I say, what does the single judge say? We permit you to read from that. You don't have to memorize, you don't have to say verbatim what the judgment says without looking at it. Court argument is exactly the opposite. When the court asks you to say something, you start looking at the document.
Yes.
So where will you see this judgment? Which page will you come to?
Page number 17.
No, 17 is all cost titles. Okay. Correct?
Yes, sir.
The actual judgment begins at 90.
Yes.
If you've read it, you'll know what the operative portion of this judgment, what the reasoning of the judgment is. Correct? Come to page 20. How to catch the reasoning of the judgment, right? In page 20, in the penultimate paragraph, you know what penultimate is, right? Sir.
Sorry, sir.
Do you know what penultimate is?
No, sir.
All right. Penultimate means last, before the last, there is one paragraph, that's penultimate. Ultimate, penultimate. All right. So penultimate is earlier than the ultimate.
Yes.
So that penultimate paragraph, if you read, you'll get the reasoning of this judgment. Just read it.
In view of the factual.
No. Page 20, sir.
Page 20.
What's the last paragraph? How does it read?
Last paragraph, it is written that it is the considered view.
So that is the ultimate, last paragraph. Penultimate means what? Earlier than that. How does that paragraph read?
The order of revision having.
Order of reversion.
The order of reversion having been challenged by the petitioner before this court under its writ jurisdiction in OJC number 969 of 1991, wherein the division bench of this court has approved by the decision of the
has approved the decision
of the authority of reverting the petitioner to the post of senior stenographer.
So what is this? What is the single judge telling you? He says you earlier came to this court, you challenged your reversion, you did not succeed, that writ petition was dismissed. Now all they have done is recovered the salary that they paid you. So you cannot now claim that salary, differential salary, because your reversion was approved by the court itself. That is what the single judge is saying.
Yes, sir. But according to as my senior mentioned that under section 74 subclause D of the Orissa Service Code, the pay of an employee cannot be lowered down under any circumstances.
No. If your reversion itself has been approved, there was a question of the pay not getting recovered. Once your reversion, in that writ petition, you would have argued all this, correct?
Yes, sir.
But anyway, so now it does seem that on your argument, we cannot allow your writ appeal. All right. So we will adjourn it. But at least you made a try.
Yes,
we appreciate that.
Thank you, sir.
And I hope you have learned something today. No.
Yes, sir.
You have learned something.
Yes, sir.
All right. You say counsel for the appellant states that he is in some difficulty today and needs some time to prepare and argue the writ appeal. List on. So have you asked your senior when he is free? Please tell your senior, sir, today I prevented our writ appeal from being dismissed. All right. 13th February. All right.
My lord, my presence may be occurring.
Certainly, sir.
Yes, obliged.
He will also acknowledge you for not interfering with his argument.
It is very encouraging, my lord. My lord.
We all have to make a beginning somewhere.
Item number 5. Item number 5.
May I please?
Yes.
My lord, there is delay of 46 days. The impugned order is dated 5/9/2008.
See, you've made persuaded what we could not persuade. Mr. Party to come to the court.
First up, it is very easier for me to. That's why.
See, now we know how to bring you to the court. 46 days. All right. All right. No, so now, what is the explanation for the 46 days?
Because it is my expansion with regard to that, my lord. Though the certified copy is obtained on 6/9/2018, it is sent to the authority.
But all blank. It was submitted to department on dated dash.
On 13/9/2018.
No, that was later. Just see before that, para 2.
Yes, my lord, para 2.
The same was submitted to the department by the conducting council on dated dash.
22nd, 2018.
No, because after that, next date is per letter dated 13/9. So it has to be some earlier date.
28/9/2018. As per the decision dated 29.
I don't know. You read your whole para 2.
Yes, my lord.
Read that.
That though the order dated 5/9/2018 passed by the Honorable Single Judge was received by the conducting council on 6/9/2018, and the same was submitted to the department by conducting council on dated.
What is there? Is there a date? No. At least we both have the same copy.
My lord, for that I am silent. Because earlier we are not there.
You know what? Justice Raman is relatively new to this whole thing. I have stopped reading paper books. I stopped reading applications. I stopped reading writ petition, what is drafted. Because everywhere you'll find some blank, some grammatically wrong sentence, some wrong fact. So I had stopped reading.
We amendment of Rule 20. I think it will be overcome.
Correct. This is only in the interest of the bar. I was just telling Justice Raman also, see, it is in our collective interest that we maintain a certain standard at the bar. If you let it slip, then the youngsters will only pick up that lower standard. They will not know what the better standard is.
When we are drafting here, when we are going to draft it in Delhi or the Madras or the other.
No, generally, sir, it has to improve.
Generally, the synopsis and
also,
all these things.
You yourself know, Mr. Party, once you drafted with the list of dates, you're better prepared to argue.
Natural.
Look at the better counsel who argue here. They're all, they marshal the facts correctly.
My senior also always guide us, has to go to that chat, then you come to
Correct.
Otherwise, don't touch the briefs.
Correct. Anyway, so what we'll do is we'll issue notice on this application for delay. All right.
My lord, I have already appeared. The notice has already gone.
So what is it? We'll condone the delay.
46 days.
Be kind to him, sir. Let's condone the delay. Let's condone the delay. You be kind to him. Delay condoned. So
some cost may be avoided.
now, poor man, he's as it is in a difficult position.
But it is not a mercy court, it is a court of law. Everything has to be go.
All right. Let's see if he succeeds. Now, 10% success. Now come to the main appeal.
Well, I have not received the writ appeal. Only which case?
That's really kind of you then. Without receiving the writ appeal, you've allowed him to.
Only notice has
delay is condoned.
Gone in which case? Not in. Delay has not been
appeal. You say copy of the paper book we served on counsel appearing for the respondent today itself. List on 14th February.
Well, obliged.
So instead of cost, you just get him a cup of tea.
Yes. Sure. I am the neighbor of my senior, so I see. Double.
All right.
I express my gratitude to my lord that my lord has started teaching the youngsters, then they will encourage slowly.
Yeah. We'll bring about change.
Yes.
Yeah.
Obliged.
All right.
Pastor matter item number 8. Item number 8.
Farida, no? You wanted a password for Farida. No, but the adjournment was sought for Farida. Yeah. Appear from, even by hybrid mode. On the first occasion, a password was granted to enable the lawyer to appear at least in hybrid mode. On the second call, none appears. Dismissed for non-prosecution. Both matters.
Item 8 and 9.
My lord, sorry, my lord, I interrupted. Let's me reflect along with me, Mr. Pati.
Of course. Yes.
Item 42.
42, my lord. Similar question has been framed by my man.
The question has not been framed. Only notice has been issued.
Yes.
42. That everywhere that I is allowed, and then list along with STREV 8 of 2019 on 26th April. All right.
Item 43. Item 43.
None appears to spread a password. Dismiss for non-prosecution.
Item number 44.
44 is similar to 42.
Same. Then give us the list of numbers.
Yes, ma'am. I'm just giving.
All right.
Item 45.
45 same, my lord. Then 48. Then 49.
45. 26 4.
45 also, no?
Yes, my lord. 45. Then 48, my lord.
48.
48 same. Then 49. 50.
Item 50.
50 is also.
50 is different, my lord.
50 is different.
15.
And then another case presented. 51 is also. 51.
51 is same, my lord. 50, then 53, my lord. It's all, my lord.
All right. Okay. Now 50.
Item 50.
Your Lordship, in this case, Your Lordship might have remembered that it is covered by the judgment of NALCO. So far as that input tax credit, Your Lordship, raw material, it's a raw material.
Right.
That against that NALCO judgment, Your Lordship, department is before Supreme Court.
That's what.
And for that reason, Your Lordship, many matters, Your Lordship was granted Senate.
Correct.
And all those matters to be listed after disposal of that.
So give us one of those things we listed along with that.
Your Lordship. Your Lordship, in this case, this case is
slightly different.
Your Lordship, slightly different. Your Lordship, here, NALCO, the previous matter, Your Lordship might have remembered that review.
Right.
Against that original read, the SLP number is 38103. 38104 of 2013. That was pending before Honorable Supreme Court. Just so in the past page, Your Lordship may kindly.
You say it is stated that the questions urged in the present case would have to await the decision of the Supreme Court in the specially petition filed by the state of Orissa, being SLP civil number
38103.
38103
38104 of 2013
-04 of 2013. All right.
Against the
it's all right. Adjourn sine die with liberty to the counsel for the state to mention this petition for listing after disposal of the above SLP.
So that order, your lordship, was passed in SCC. That is not here. That is not covered here,
Okay,
your lordship.
okay.
That is suppressed the entity tax scheme.
All right.
Item number 70.
May I please, your lordship? Lord, this matter is covered by your lordship judgment, where the issue is a delay in submission of the AVR, my lord. Beyond the period of 7 days. It's covered, my lord. And I'm also submitting
42.6.
To substantiate, my lord, my submission, I have handed over the certified copies of the order sheet of the, my lord. If your lordship kindly turn to second page of that order sheet, lordship will find on 7/4/2014, the audit was completed. And the same was received by the DCST. Second page of the order sheet, my lord.
Around 2 months. Around 2 months.
So squarely covered by your lordship's order.
Yes. What do you say?
The whole pleading is regarding 42.6, my lord.
No, in paragraph, my lord, in paragraph 15, I have categorically taken that point.
All right. The challenge in the present petition is to an assessment order dated 11th September 2015, passed by the Deputy Commissioner of Commercial Taxes, Barbil, under Section 42 of the Orissa Value Added Tax Act, 2004 (OVAT Act), for the tax period 1/4/2011 to 31/3/2013.
My lord, the first it is regarding central sales tax.
No, VAT. First is VAT, second is CST.
18698 is VAT, sir.
Yes.
The same principle.
Right.
The same.
Same.
31/3/2013. Full stop.
Already.
While directing notice to issue in the present petition on 4th November 2015, this court stayed the demand raised by the said order. Paragraph. The facts in brief are that a notice dated 17 September 2014 in form VAT Roman capital 4 was issued to the petitioner. Sorry. Notice was issued in form VAT 301 on 5th October 2013, fixing the date of the audit visit as 24/10/2013. Full stop. The petitioner states that it produced the required documents for the purpose of audit. Full stop. The audit was completed and the audit visit report was submitted on 7th April 2014. Full stop. On that basis, a notice in form VAT 4 was issued to the petitioner by the department on 17/9/2014. Paragraph.
Lordship, on the delay is there, but that AVR has been received on the 14th May 2014. Stamp is there, and that has not been mentioned in the order sheet.
All right.
The assessing officer's stamp is there.
All right.
Is that within 7 days?
No,
Is that within
beyond
7
7
days?
No, obviously not.
Only so far as the date.
Narration. You can say at this, Mr. Sunil Mishra, learned additional standing government advocate for the department, informs the court by perusing the original record that the audit visit report is received
By the Joint Commissioner on 14th May 2014.
Yeah, no, it's okay. By the Joint Commissioner.
Yes.
No. On 14th May 2014. Full stop. Paragraph. The mandatory nature of the time limits set out in section 41(4) of the OVAT Act that the report must be submitted within 7 days of the conclusion of the audit visit has been emphasized with this court in its order, in the context of an identical provision in the Orissa Entry Tax Act 1999, bracket OEP Act, namely Section 9-B, bracket 2, in an order dated 28 June 2022, in writ petition civil 9856 of 2010, bracket Messrs. Grihasti Udyog versus Commission of Sales Tax. Paragraph. With the said time limit not having been adhered to as far as the present case is concerned, the court has no hesitation in concluding that all proceedings consequent to the said AVR, including the impugned assessment order, are unsustainable in law, and the impugned assessment order is accordingly set aside. The writ petition is allowed, no orders is to pass.
But so far as the second matter is concerned, my lord, same thing, but it pertains to CST.
In 18698 of 2015, for the reasons stated in the order passed today in 18696 of 2015, which is in the context of proceedings under the Orissa Value Added Tax Act, Section 41, bracket 4 of the Orissa Value Added Tax Act 2004, the impugned assessment order in the present case, which is under the Central Sales Tax Act, is hereby set aside. But in this
696.
698.
698 was the earlier one.
696 is this one.
Yes.
Yes.
This is CST.
This is CST. All right. Is hereby set aside.
14th May stamp is also at Annexure 2 above in the audit report itself. It has been received at 14th
All right.
May.
This can be given back to me. No. 898 is Section 42.
696. I'm seeing nomenclature is given. Application.
Pleasure.
All right.